For what? All right. Yes. Only urgent matters will be posted tomorrow. Only urgent matters will be posted tomorrow because the board is full. So we will take it probably after day after tomorrow or next week. I can't hear you. Be louder. In what does that matter? Hey, which is that classification? Who are you? What petitioner are you? Who are you? Owner, driver? Who are you? Insurance. Owner of the vehicle. You pay the deposit, the amount. 50% you deposit day after tomorrow. Go and execute. Go and file contempt if they are violated. Or warrant is issued for non-payment. So why don't you pay? Post it. Now, what is the classification of your petition? GMR. I don't think we are having that. He has 482. Which court he has to go? Somebody can guide him. Which court he has to go? So you, Mr. Counsel, you need not go on the name of the honorable judge. He is not sitting here in this bench. Go to the roster bench, probably next court. Yes.
Adjournments, page wise. Page number 11, serial number 44 and 45.
Serial number 24, my lord. The matter has to be, there are connected matters which are before the division bench, my lord. Hence, it may kindly be adjourned, my lord. It will be posted before the division bench.
Which one, madam? Serial
Number 24, my lord.
24, is it?
The connected 3 matters have been filed by the corporation, my lord.
24.
Adರಲ್ಲಿ ನಾವು ಕಾರ್ಪೊರೇಷನ್
24 ಒಂದೇನಾ?
ಅದರಂತ ಸಮಯ ಅದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗ್ಬೇಕು ಯಾಕಂದ್ರೆ ನಮ್ದು ಕನೆಕ್ಟೆಡ್ ಟು ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದೆ ಅದಕ್ಕೆ.
So learned counsel for the respondent corporation Allah submits that there's a 2 other matters are pending before the division bench.
Yes, ma'am.
Hence call this matter next week. You tell the division bench to call this matter there, madam.
Well, serial number 33, madam. Serial number 33.
Yes, Mr. Shastri.
Ravi Samprati is not appearing for HDFC, so his name may be deleted as he informed, and HS Lingaraju names may be shown, Malad.
Registry to delete the name of learned counsel Ravi S. Samprati for R2 and show the name of
HS Lingaraju.
Yes, Lingaraj. You will take.
Yes, I will.
Show the name of learned counsel Sri HS Lingaraju. Lingaraju, na? Lingaraj as counsel for R2. Who are you? This is your claimant?
I am for claimant.
Whether the delay can be condoned? I1 of 24 allowed, delay of 36 days condoned. Yes, list for admission. After 2 weeks, copies to be served.
Yes, yes.
Yes.
Page 11, syllabus 44 and 45. Page 12, 46 to 53.
My lord, serial number 53, my lord. I appear
Yes.
for the respondent.
Hmm.
I appear for the respondent in serial number 53. In
Yes,
the
ma'am.
last two connected matters, I made to file wakalat.
Hmm.
Can I request for a week's time, my lord?
Yes, yes. Worked. Learned counsel for the corporation, Srimati Renuka HR, seeks time to file wakalat and secure instructions. Call this matter after 2 weeks. Have you been served with a copy?
My lord, I have not been served, my lord. I'll check with the counsel for the claimant, my lord.
All right, the appellant counsel to serve copy of the appeal memo to the learned counsel for respondent corporation. Call after 2 weeks. List on. Date could be.
Page 13, syllabus
Yes.
54.
Yes. All right. At request of counsel for appellant, list this matter next week.
My lord, serial number 54, my lord.
52, Vijay Kumar ನೀವು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
Please, my lord. I'll
So,
file wakalat.
he is taking time. Please file
Please,
wakalat
my please,
and
my lord.
have it next week. 52.
Please, my lord.
54, you want anything in 54?
No, I thought that somebody is moving in serial number 54.
This was 52.
Page number 14. Note ಮಾಡ್ಕೊಳ್ಳಿ sir.
Correct.
Page number 14, syllabus 55 to 58. Page 15, 59 to 62. Page 16, 63 to 66. Page 17, 67 to 67 and 68. Page 18, 69 to 75.
Yes. Your petitioner,
Dharampal.
you are at request of counsel for petitioner, call this matter on. Date could.
ಹಾ ಸರ್ ಕೊಡ್ತೀನಿ ನಾನು. 15 next week.
71. You're for petitioner. All right. At request of learned counsel for the petitioner, call this matter on so and so.
15.
Interim order idea. What is the interim order? All right, interim order to continue till next date.
Page 19, serial number 76 to 80. Page 20, serial number 81 to 85.
81 at request of learned counsel for the respondent.
6, R6.
Respondent number 6, Anivo. R6, we call this matter
After 2 weeks.
after 2 weeks. Serial number?
83, sir.
Yes. At request of learned counsel for the appellant, call this matter on
Next week, is it?
next week.
15. Page number 21, serial number 86 to 88. Page 22, serial number 89 to 93.
You're for whom? Your respondent. He's appearing for whom? Claimant or owner? Insurance company. At request of learned counsel representing the insurance company, call this matter on
21st.
21st.
Page number 23, serial number 94 to 99. Page 20.
Request of learned counsel for the respondent. Final hearing. I'll list this matter on. When do you want to, on that day you argue? After? Give a date.
17.
Yes, 17th.
56.
96. Huh? 4 weeks. 96. These are, what is this matter? It's a MFA MVC matter. Correct, Ray? Why you need 4 weeks? An objection in that. 2 weeks I'll grant you, get ready. You have the papers. Request of learner, you're HCGP? At request of learner, HCGP. List this matter on.
22nd,
Yes.
page number 24, serial number 100 and 100 to 102. Page 25, 103 to 105.
Serial number 104, my lord.
Hmm.
For the appellant in this case, seeking 2 weeks of time, my lord. As the senior is not present in account.
Your appellant,
Yes.
request of appellant, call this matter after 2 weeks only.
21st. For orders, serial number 1, Srimati Manjula and Tejasvi.
I am for appellant, Your Honor. Kindly grant short accommodation for take steps.
You have to take steps for 4 and 5. New 1 to 3, na? Who's 4 and 5? Owner of the vehicle. You have filed any appeal? Your claimant. You have not filed any appeal. So they want to shift the burden on the owner. Learned counsel for the appellant seeks time. Call this matter on.
21st. Serial number 2, Kailash Shankar PS.
I'm appearing for appellant.
Hmm.
I'm appearing for appellant, madam. A case of death, madam.
Who's appearing for respondent?
YP Venkapati.
For R2,
Please, ma'am.
he is not here.
What's 2 weeks time, please, in this case?
Huh?
In this case, what 2 weeks time? What, that's ending.
He wants 2 weeks' time. At 21, we are in 25. Barcode, counsel for appellant is present. Counsel for respondent number 2 seeks time. 2 weeks' time is granted as a last opportunity. Is this matter on?
21st.
Now,
Serial number
why
3.
is it listed in orders?
I'm filing of one.
R2 ಗೆ ವಕಾಲತ್ ಹಾಕಿರ್ಲಿಲ್ಲ ಅಂತ ಬಟ್ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ವಕಾಲತ್ ಆನ್ 22/8/22 ಮೇಡಮ್
ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ
ಎರಡರಲ್ಲೂ?
ಇನ್ಫಾರ್ಮೇಶನ್ ಬಿಟ್ರು ಬೆಳಗ್ಗೆನೆ.
Then we will list it for hearing.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
List this matter for hearing.
Serial number 3, DP Radha.
Hearing for the appellants, my lord.
Hmm.
The process has been issued, but
Refuse
to R2, but it's not claimed, my lord.
about,
So if it can be deemed as served,
you're for the insurance company,
yes. KSRTC, my lord.
corporation. Barcode, learned counsel for the appellant is present. Notice to R2 is written with the Shara as refused. Hence notice is held to be sufficient and deemed as served. Registry to show the name of R2. What about the next case? You are already on record. This 84 days delay can be condoned.
Yes, my lord.
Barcode, IA 1 of 22 filed under section so-and-so for condonation of delay of 84 days being satisfied with the reasons assigned and cause shown. The application is allowed, delay of 84 days is condoned. Yes, list for admission. Now all matters date will be given.
21st. Serial number 4,
Much obliged.
My lord, I am for the appellant, my lord. My lord, I have already filed the memo for dispensation of notice to respondent number 6 and 7.
Mr. Shivkumar,
Please, my lord.
1 minute, Vijay Kumar.
Please, my lord.
Madam, in that, now nim case alla 3 alli,
serial number
whether
3.
R2 in that first matter is there in the second your matter?
BC Shivanegowda is there.
ಇಲ್ಲ ಇಲ್ಲ ನಿಮ್ ಕೇಸ್ ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ.
ಅಲ್ಲ ಅವ್ರದ್ದಲ್ಲ 3 ನಲ್ಲಿ.
ಹಾ? So Shivarna Gowda's appear for R4 in your case is R2 in the first case. It can appear in that case. Hmm? R3 are held sufficient. All right, doesn't matter. Same. Yes, Mr. Vijay Kumar.
Please, my lord, in serial number 4, my lord, I have already filed the memo for dispensation of notice to respondent number 6 and 7 on 21/8/24. Kindly direct the office to put up the memo and kindly pass order, my lord. Memo is already in the file.
Memo idea. He made this. When have you filed the memo?
My lord, on 21/8/24, I have got the acknowledgement also. 21/8/24.
No such memos there. Learned counsel for the appellant submits has filed a memo seeking dispensation of notice to R6 and 7 registry to put up the memo. All next week. List on.
Much obliged.
Till number 5.
Steps for R2.
For the respondent.
Speaking for the appellant, my lord. Responding number absent in MACT, so requesting for paper publication, my lord.
ಮೈಕ್ ಕೊಟ್ಟಿದೆಯಲ್ಲ ನಿಮಗೆ ಮೈಕ್ ಇದೆಯಲ್ಲ ಅದ್ರಲ್ಲಿ ಮಾತಾಡಿ or be loud enough that you don't need the mic.
R2 absent in MACT, my lord.
Hmm.
So is located in Kohima, so requesting for paper publication, my lord.
Paper publication.
ಹೌದು.
Have you filed IA? You want to file?
ಇವತ್ತು ಫೈಲ್ ಮಾಡ್ತೀನಿ.
ಮಾಡ್ತೀರಾ? Counsel for appellant seeks time to take steps for R2. Call this matter on next week date.
Sufficient. Climates also filed an appeal, my lord.
What is number?
452 of 2023.
It's along with MFA.
452 of 23.
452 of
23.
23.
Please.
Till number 6.
Much obliged.
Satish Shetty. DPF.
Is DPF? Learned counsel submits. You would do the needful during course of the day. If needful done, issue notice to R2.
Till number 7.
Happy for the appellant. Request for a 2 days time.
2 days time is sought for by learned counsel for the appellant for the need to do the needful. If needful done, issue notice to R1.
Grateful, ma'am.
Till number 8. Mohan
Okay.
Kumar T.
Taken of
Publication.
paper publication is Samyukta Karnataka. My lord, in respect of respondent number 3 is the resident of Madikeri district. I have taken in Madikeri district only. It's a Mangalore edition, but it is wrongly mentioned as Bengaluru ತಗೊಂಡಿದ್ದೀರಿ ಅಂತ. But Bengaluru ಅಂತ mention ಆಗಿರುತ್ತೆ. In the first page, it is mentioned as Bangalore, Hubli, Kalaburgi, Davangere, Bagalkote. The particular page, my lord, is 9. My lord, in respect of Madikeri district. That page 9 of the paper, your lordship. Kodagu edition.
Who has stitched this? You have filed this?
As per this.
If you stitch the newspaper like this, how to open and see?
Sir, I'll check.
Trial court practice ಮಾಡಿಲ್ಲ ನೀವು?
ಇಲ್ಲ ಅದು
You have done extensive trial court practice.
ಇಲ್ಲ ಆಫೀಸಲ್ಲಿ ಕೇಳಿರ್ತಾರೆ, ಸೊ ಹಾಗಾಗಿ my colleague has stitched.
You should stitch it in such a way that once you open, the entire newspaper should open, sir. How to see this now? You have to open it and show it.
I'll open it and I'll.
Open ಮಾಡ್ಕೊಡಕ್ಕೆ. Whether IA was allowed to take
Yes,
out
my lord,
in-
I was allowed and I have taken.
No,
paper.
IA was allowed to take out in Bengaluru or Mangaluru.
Mangaluru edition
Ah.
circulating in Madikeri district. It is circulated in Madikeri district.
Madikeri.
Madikeri.
So that is-
That's the reason, my lord, page number.
That is shown there.
Yeah, it is shown. Kodagu.
Okay.
Kodagu ಅಂತಿದೆ.
Cut it.
Page number 9.
Published ಎಲ್ಲಿದೆ ಅದು ನೋಡಿ.
This particular page, my lord, are relating to Kodagu district.
ಎಲ್ಲಿದೆ?
Left hand side al Kodagu ante.
ಹಾ.
Kodagu and Somarpete. Kushalnagara, Somarpete. So this is entire page, my lord, relating to Madikeri district.
So Mangaluru, Kodagu and all everywhere.
Mangaluru is a edition. Mangaluru edition, my lord, covers Madikeri, Mangaluru, Udupi, idella cover agutte. If you say circulating in Madikeri, andre only the Madikeri, my lord, news will appear in page number 9, in the particular page.
Mangaluru ಇದೆಯಲ್ಲ ಅಲ್ಲಿ.
ಇದೆ Mangaluru ಇದೆ, first page Mangaluru ಇಲ್ಲ.
What is the objection?
Objection, they have mistaken that I have published in the Bangalore edition ಅಂತ.
First page ಅಲ್ಲಿ ಮಂಗಳೂರು ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
ಹೌದು. Office has made a mistake.
Good. The notice to respondent number
3.
Follow the name.
Respondent number 3, Shri D. Shivaram, son of Dharmaraj.
To respondent number 3, Shivaram. Notice to respondent number 3. Is taken out through newspaper publication. In Samyukta Karnataka, Kannada daily newspaper. Published on 15/12/24. Respondent 3 is called out in the open court. There is no representation, either by himself or through a counsel. Hence, notice to R3 is held to be sufficient. Registry to show his name in the cost list. All on.
Dilemma 9, Shripad V. Shastri.
My lord, I am for appellant. I seek dispensation of notice to R1 and R2. And also there is an IA for delay for 55 days.
Who's 1 and 2?
Owner and driver of the vehicle.
Insurance company has not filed any appeal?
No. Not filed any appeal. And Pradeep is directed to take notice.
He's already here.
Please, my lord. Plus weeks time, my lord, to file wakalat, my lord.
Notice to R1 and 2 is dispensed at request of appellant. Memo is accepted. Learned counsel Shri Pradeep, B. Pradeep is present for R3. IE1 of 24 is filed to condone delay of 55 days. Being satisfied with the reasons assigned cause shown, delay is condoned. IE1 of 24 is allowed.
Please,
Copy is ಬಂದಿದೆಯಾ? Copy.
please, my lord, copies bonnet.
Dilemma 10, Shripad V. Shastri.
My lord, I am for appellant, my lord.
Ah.
I seek dispensation of notice to R1 and there is a delay, my lord.
Alright, same madam. Notice to R1 is dispensed. Memo is accepted. A.N. Krishnaswamy. IE1 of
Just file the wakal.
24 is filed. He has not filed wakalat.
He is not filed wakalat, my lord. Before vacation it was posted.
We'll have it next week.
Oh,
We'll
I
call
think.
this matter next week on.
15-1. Dilemma 11, Dharmapal.
Yes, sir. My lord.
Yes, Mr.
I have
Dharampal.
taken steps 2 times, sir.
Ah.
Before the office on the 30th October 24
Hmm.
and previously 14th August 24.
Hmm.
R5 is the insurance company.
Insurance
I think
company.
it is pending in the office
Which insurance?
directed to verify.
New India.
Pardon?
New India.
ಹಾ ಅಲ್ಲ ಸ್ಟ್ಯಾಂಪ್ ನೀವು ಇಂಡಿಯಲ್ಲ
R5 ಅಲ್ರಿ.
R5 ಯೂನಿವರ್ಸಲ್ ಸೋಂಪೋ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಲಿಮಿಟೆಡ್.
ಮತ್ತೆ ಇವರು ಪ್ರದೀಪ್ takes ಅಲ್ಲ.
I filed a LR application on 19.
ಯೂನಿವರ್ಸಲ್ ಸೋಂಪೋ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ನೀವು ತಗೊಳ್ತೀರಲ್ಲ. You appears for New India Assurance. New India Assurance ಯಾರಿದ್ದಾರೆ? ರಾಜು.
PB Raju, sir.
PB Raju. Okay. Correct. Learned Counsel Shri PB Raju is directed to take notice for R3. R3 New India Assurance.
New India R3.
Learned Counsel Shri B Pradeep is directed to take notice for respondent number 5. Copies to be served. All this matter on.
Still number 12.
Purti Hegde, permission.
Respondent number 2. Weeks time may be granted, I file wakalat because they have.
ನೀವು appeal ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ. They have not served the appeal memo in order to know.
R2 is owner.
Owner of the vehicle, liability is on the insurance
You
company.
have not filed.
I don't know because they have not served the appeal memo.
I will
For
serve.
weeks time may be granted, I will file the appeal memo.
You want dispensation.
Dispensation to R2, my lord.
We'll have that next week. In case he files and he is disputing, then R2 may be required.
Please, my lord.
He says that we have already satisfied the award. That's what he said. Therefore,
Satisfied?
Yes, ma'am.
And not required.
that's
Notice to R2 is dispensed at request of the appellant. Memo is accepted. Weeks time granted to R1 to file wakalat. Colon.
Please.
In one. Still number 13.
R2 is the driver of the vehicle. I'm filing a memo dispensation to the R2, please. In both the case.
Notice to R2 is dispensed at request of appellant. List this matter on
Next week, please, I'm ready for disposal.
after 2 weeks. Date code after 2 weeks.
21st.
Both same, 13, 14, same.
21st. Still number
Same order,
15.
madam, 13, 14.
Pradeep B.
Notice to R1 correct address.
Respond number 1 and 2 second time.
Ah,
Plus weeks time alert.
weeks time granted. If needful done, issue notice to R1 and 2, colon.
15 1. Number
Acceptance of
16.
notice by substitute service. Azimuddin,
Azimuddin M.
Preparing for the petitioner, my lord. Steps has been taken through paper publication in Indian Express English daily newspaper on 26/11/2024.
for which respondent? Only respondent.
Respondent number 1.
Huh?
Respondent number 1.
What is it? And this is an
Respondent
RPF.
1. Basira Begum.
What about 2 and 3?
Since they are minor, represented by respondent number 1.
Is there any other petition filed between the parties?
No, my lord.
How many times you have taken out notice by registered post?
3 times, my lord.
The 2 and 3 are minor children.
Yes, my lord.
They are residing with whom?
Respondent number 1.
So you have paid the maintenance amount. Have you paid the maintenance amount?
No, my lord.
You are not paid at all.
No, my lord.
Why? Orders of 2017.
I have filed this petition to set aside the ex parte judgment passed by the first additional family.
You had not participated. All right. And why it is pending from 2018? Notice ಹೋಗ್ತಾ ಇತ್ತು ಅವಾಗಿಂದ.
Notice was not served, my lord.
Worked. Notice to respondent number 1. You have taken out notice to R1. What about 2 and 3?
Since they are minors represented by their
Then
mother.
you have to take notice to them also. They are minors represented by the mother.
Represented by respondent number 1, my lord.
Why you have not taken? You take out notice to the minors 2 and 3 by registered post to the same address. Let it come back. You have conveniently not taken. Take out notice. Notice to R1 is has been taken out through newspaper publication in Indian Express, Indian Express English daily newspaper dated 26/11/24. R1 is called out. There's no representation by herself or through her counsel. Hence notice is held to be sufficient.
R2 and R3 are residing with mother only.
Learned counsel to take out notice to respondent 2 and 3 by registered post. Take out notice to 2 and 3 in the same address. Let it come back, we'll see.
For the petitioner. My lord, the petitioner has assailed the correctness of, my lord, the exorbitant maintenance order passed by the family court, my lord, of Chikamagaluru. The honorable family court, my lord, has proceeded to determine the quantum of maintenance only on the basis of 2 documents, that is Exhibit P1, the marriage invitation card, and Exhibit P13, the alleged, my lord, visiting card of the petitioner. My lord, the respondent number 1, my lord, has systematically withheld information about her financial status. She has, my lord, fixed deposits to the tune of 1 crore 15 lakhs in various bank accounts. That information has been withheld while filing petition for maintenance. And also, in considering the said, my lord, this honorable court by order dated 27/2/2024 was pleased to direct both the petitioner and respondent to file fresh affidavits of assets and liabilities before this honorable court. I have also filed, she having filed the similar affidavit, my lord, systematically withheld the said information here also by filing false affidavit. In fact, 60,000 order ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. When he is getting only 32,000.
Any interim order is passed by this court?
It was passed, my lord.
How much are you directed to pay?
30,000, 50% of the
Order dated?
My lord, can I persuade my lord's kind attention to order dated 27/6/2023, my lord?
So you are directed to pay 50%.
50% of the 60,000.
That is 30,000.
30,000.
As against 60,000.
Please, my lord.
You are paying that.
I am paying
But 2-3 occasionally idagittu. In the meanwhile, she has filed petition for my lord arrears of maintenance. Adannu kuda pay ಮಾಡಿದೀವಿ ನಾವು. In the meanwhile, my lord, the honorable trial court, my lord, has issued, my lord, warrant, my lord, despite the fact, my lord, the matter is pending before this honorable court.
Yeah, this court has granted you in stay of that, subject to your payment of 50%.
ಅದನ್ನು ಕೂಡ ಮಾಡಿಫಿಕೇಶನ್ ಕೇಳಿ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಇನ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ದಟ್ ಅಪ್ಲಿಕೇಶನ್, ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ವಾಸ್ ಪ್ಲೀಸ್ ಟು ಡೈರೆಕ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂಡ್ ಆಲ್ಸೋ ಪಿಟಿಷನರ್ ಟು ಫೈಲ್ ಫ್ರೆಶ್ ಅಫಿಡವಿಟ್ಸ್ ಆಫ್ ಅಸೆಟ್ಸ್ ಅಂಡ್ ಲಯಬಿಲಿಟೀಸ್. Even in that affidavit also, she has suppressed, my lord.
Right, I will consider that. I'll consider.
I am filing counter affidavit also, my lord, in order to demonstrate that she has withheld the information.
P. Nataraju.
P. Nataraju ಅಲ್ಲ, ಬೇರೆ ಯಾರೋ entry. NOC.
ಯಾರು?
Utsav Gowda.
Nataraju is given NOCs.
Yes.
Utsav Gowda. Already you filed that in the office, serve a copy.
Please, my lord.
Consider it. You continue to pay the amount.
Please, my lord. Till then, my lord, no precipitative action, my lord.
No, you are directed to pay the arrears.
Yes, I am paying, my lord. But what has happened is, my lord, the trial court, my lord, based on 2 applications filed by the respondent during the pendency of this petition, my lord, has issued, my lord, warrant, my lord. And in fact, my lord, in 498A case, my lord, challenging the FIR, my lord, I have filed petition before this honorable court. There is a stay. There was a oral direction from this honorable court to explore the possibility of settlement. Even that was also brought to the knowledge of honorable trial court to recall the.
What is the arrears you have to pay now?
30,000, my lord. Sometimes what happens, my lord, is getting only 32,000. Is a, my lord, lecturer in a government PU college. He has to maintain his parents also. Sometimes 10,000, 15,000 ಈ ರೀತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಉಳಿದಿರೋದಕ್ಕೆ ಅರಿಯರ್ಸ್ ಬರಬೇಕು ಅಂತೇಳಿ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು now she has obtained warrant, my lord. The honorable trial court, my lord, is not.
Where is that application of yours filed?
My lord, I number 4, my lord.
That is returned with objections. Is IA4 of modification, Allah?
That modification, yes, sir. I mean, one more application, my lord. It is dated 5/9/2024. That is criminal miscellaneous number 147. 2023 and criminal miscellaneous number 104 of 2024. These 2 applications are filed during the pendency of this petition.
Correct, sir. They are all recovery proceedings.
Correct. Adರಲ್ಲಿ warrant ಆಗಿರೋದ್ರಿಂದ ಸ್ವಾಮಿ is not able to explore the possibility of settlement also. On the
Deposit the amount.
I will do it, my lord. The fact remains, my lord, because of financial crisis, my lord, is not able to.
Again, crisis. You are already a PUC lecturer.
Correct, my lord. Not as a guest faculty, What
is your salary?
My lord, when the petition was filed, it was 13,000. Now it is 32,000. He has to maintain his aged parents also.
Where is that warrant? Where is that application?
My lord, that is an application filed on 5/9/2020.
5/9?
5/9/2024, I have filed.
That is not here.
While seeking extension of interim order dated 27/6/2023, my lord, I have pleaded this honorable court to interdict the proceedings in the said 2 applications, my lord.
No, your IA4 is for modification.
Modification, my lord. When modification application is pending, my lord, she has proceeded to file. In fact, she has not filed even objections also.
Where is the bar that she cannot proceed? Modification is not heard, no order is passed.
My lord, it was considered, my lord, based on that application only. In fact, the coordinate bench of this honorable court, by order dated, my lord, 21/2/2024, my lord, directed both the petitioner and respondent to file fresh affidavits.
That application modification is 31/10/23. IA4. When is a warrant issued against you?
My lord, subsequent thereto, my lord, I have not placed it on record.
It's not here. File that with a separate application. We'll consider that. File that with a separate application, issuance of warrant.
Please,
In which proceedings? That is not in this proceeding. This is culminated. You are
Yes,
now here because of maintenance.
correct, my lord.
That is stayed.
Please,
Execution of that, one more miss is filed.
please, my lord.
So you have to file that here. What is that number? That is not here in this.
It is there, my lord. Criminal miscellaneous number 147/2023 and criminal miscellaneous number 104/2024.
When is that filed?
It was filed on 5/9/2024.
This application itself is 23. How it will come in this application?
One more application I have filed. my
Where
lord.
is that?
I'm sorry, my lord. While praying for extension of interim order, my lord, I filed that application on 5/9/2024, my lord. Please.
Fine line yaudilla. Only February last I have your application. You file that tomorrow, day after, whenever you,
All right, my lord.
because that is not available here.
And I have it day after tomorrow, my lord.
And then counsel to rectify the objections raised by the registry by serving copy on the other side, call this matter on. In the meanwhile, you undertake that you will pay the amount, that's all.
I will undertake, my lord,
Pay the amount subject to the result of this petition. Warrant will go back.
pending consideration of modification order, modification application. The trial court may kindly be directed not to precipitate, my lord.
That we don't even know which case number, nothing is there on record here. Next.
Grateful.
For the petition, my lord.
Hmm.
My lord, the process had to be issued. My lord, but then again, it's like if I may be granted liberty to serve a copy of the petition to the advocates representing the respondent in the trial court. Because my lord, already we had issued notice once and they have not appeared before this honorable court. Now, my lord, there are few cases pending.
Granted to the petitioner. Take steps, if needful done, issue notice to respondent. In the meanwhile, learned counsel for the petitioner is permitted to take out notice to the counsel representing to the party and the counsel
Kindly.
before the trial, before the family court.
My lord, in family court, because my lord, the respondent has filed cases for dissolution of marriage and domestic violence.
Is it in family court or some others?
In family court, my lord, but it is in Sindanur, my lord.
Wherever it may be.
Yes, kind.
Yes, you are permitted. Await service of notice of respondent.
Yes, please, madam.
Dispensation.
Dispensation for the typed copy of annexure A, madam.
What is annexure A?
Order sheet of madam. Entire order sheet of MC.
All right, await service of notice. to Respondent. Obre na?
House. Respondent is the husband of the petitioner.
You are appearing for the wife.
Yes, my lords. Interim prayer may be considered, my lords. On 13th is the next date on family court, my lords.
What is the order you are challenging?
Its order has challenged to set aside the order passed by the honorable trial court in IA number 4 and 5 to recall and reopen the stage of file the objection of the petitioners, my lords.
Take out notice on the council or the party before the family court. Which court?
Family court, 5th edition.
All right, learned. In the meanwhile, counsel for petitioners permitted to serve notice on the respondent or the counsel representing the respondent before the family court at Bengaluru.
Please, ma'am.
Call on. When is the matter?
13th, my lords, on next Monday, my lords.
All right.
Kindly have it
Before
on-
that one date could. All right, fine.
Obliged.
Non-compliance.
In fact, this matter was listed on 20th of December 2024. My lords, I had made, before the coordinate bench, I had made a submission that, my lords, I had filed an application, a copy application seeking the speaking order that was passed. My lords, it's been more than 4 months. I have not been given the copy, point number 1. My lords, what's happened there is when I inquire with the Sharistadar, I have been informed that the separate order, that is the speaking order, has been misplaced. Then I have also been informed that the order is in the server, but the trial court judge is refusing to sign it. But what happens on 20th before this honorable court is The coordinate bench orally directs the registrar to inform the family court. The registrar informs, and I go on Saturday, my lords, day before yesterday, and still the order is not signed and not ready, my lords. That is the issue, my lords. Now, the problem here is this is a petition by the father. He has not seen his children for more than 1.5 years. The custody was with the father, which has been shifted to the mother. By the order dated 10/2/2022, my lords. The order sheet says at page number 23, my lords, that the order has been pronounced by a separate order. But my lords, the problem here is that they say the order is misplaced. Then they say they have the order, the speaking order in the server.
Where is the impugned order?
Page 23, my lord. I do not have a speaking order, my lords. Page 23 clearly states that IA number 2 filed by the petitioner under section 12 of the GNW Act is hereby allowed. The respondent is directed to hand over the interim custody of the children, my lords. My lords, my copy application, in fact, that I've filed is also at page number 48, my lords. I have checked the online status if I could just place it before the lordships. It still says not ready. It's,
This order was passed in February.
please, my lords, 2022, my lords.
All right, so you're not able to get that copy.
My lords, they say the separate order is misplaced. When I inquire, they say the judge is refusing to sign the order. These were the submissions that I made on 20th December 2024, my lords. Despite a direction to the registrar, after the registrar having informed, on 4th of January, when I checked the status, my lords, still it says not ready and still the order has not been signed. My lords, I'm neither here nor there. That is the difficulty.
What are the ages of the children?
My lords, 5 years and 6 years old, my lords. A 6-year-old boy, 5-year-old daughter. They were in fact, my lords, with the petitioner. It's only after a petition filed by the mother that the custody was
Made the children a party?
No, my lords, no, my lords. The petition, the cause stated in the trial court that the petition was filed by the mother before the trial court, wherein
For what?
children were seeking custody of the.
Then children are not required to be made
My lords,
in a custody petition.
my lords, they have not made the children a party in the custody petition. My lords. I have not filed the custody petition because the children were with me.
Okay, so when the petition was filed,
Please, my
the
lords.
children were in your custody on,
Please,
in December 22.
please, my lords.
The order is passed in February 23. Custody is handed over to the mother.
Please, my lords.
And
I've assailed that order before your lordships.
so since then, the children are with the mother.
With the mother, and I've had no access whatsoever. I go to the school authorities have been informed by the mother that they're not supposed
What
to.
are the age?
The son is 6 years old. The daughter is 4 years old. 5 years old.
Now, what is the objection now raised?
That the reasoned order has not been furnished. The speaking order on IA number 2.
The address of the respondent is not telling.
My lords, I have corrected the address, my lords. Whatever the address is in the trial court, my lords,
Address of petitioner respondent.
please.
Why don't you give the full cost title of the petition
My lords,
before the trial, family court? Where is that full cost title?
page number, my lords, page number 29.
20?
29, my lords, Annexure B. My lords, the petitioner presently lives in Udupi, my lords. Therefore, I had to state that address, my lords. That address is there before the trial court, my lords. My apologies, my lords. The address mentioned by the respondent in the trial court, that is the mother, that is not the address where the father resides, my lords. So therefore, I have stated the correct address where the father resides. my lords.
The objections raised by the registry with regard to serial number 2 is overruled. With regard to serial number 1, 2 weeks time granted to produce annexure A. In the meanwhile, learned counsel for the petitioner to serve copy on the respondent, please. Before the family court at Bengaluru, and also take out notice to the counsel appearing for the respondent before the family court at Bengaluru. Call this matter on.
My lords,
Give a
may,
date next
my
week.
lords, may I request the trial court to release the order, my lords, because the trial judge is refusing to sign. That is the issue, my lords.
Why are
stating
you
that
worried? What, you want the order or you want an order to see your children?
I want an order to see my children. My lords, if he is permitted to visit them at any mall nearby, my lords, until such time, please.
I'll pass that order without that order, don't worry. Go and get this.
A date may be fixed, my lords. Great.
Have a come on? No, give it earlier. He has not seen the children. 16th.
Grateful, my lords.
Meanwhile, you serve it on the council or even the party
I shall
through your letterhead as a council.
Grateful. Deeply.
We have served the copy on the other side.
There's several objections.
My lord, there are minor objections. In fact, I could not comply for the reason that, my lord, the matter was posted before the vacation bench. And the court went on up to late evening, and there we could not, thereafter there were holidays, continued holidays. We
This
could
was
not-
filed in the vacation court.
Yes, ma'am. For that reason, we could not get hold of the file, my lord. For that reason, we could not be complied with.
What are the objections?
The objection is, my lord, that the jurisdiction has to be mentioned. And some minor objections with regard to the age and other aspects, my lord.
To rectify it.
The urgency is this, my lord.
Hmm.
Section 12 application has filed before the family court.
Hmm.
Requesting the court to permit us to take the children to to Mangalore during this Christmas vacations.
Hmm.
My lord, earlier several applications were filed. The learned family judge, my lord, is not passing any orders on any of the IAs.
Hmm.
If your lordships could kindly see, my lord, page 18, order sheet may kindly be looked into, page 18, 1-8. My lord, IA number 3 was filed, IA number 4 was filed on 1-6.
Hmm.
Those IAs became infructuous. And thereafter, if your lordships could kindly turn to page 22.
Hmm.
Page 22. My lord, the order dated 15/11/2024,
Hmm.
wherein, my lord, we have filed IA number 6. That is the present IA that is impugned. IA 7, IA 8. Even though this is filed some 2 months back, no orders are passed. My lord, all IAs are getting infructuous. I'm unable to, my lord, visit the children who are minor children.
Hmm.
For that reason, my lord, for that extreme urgency, because up to 16 this vacation is there. Now, by that time, my lord, if at all, at least for 3-4 days, if I'm not allowed to take them, my lord, my very application will become infructuous. Trial court will never pass the order. Even today, my lord, the matter is listed before the family court.
Hmm.
It's more than 2.5 months, my lord, that we have.
How old are the children?
At 12 and 10 years, man. 13 and 11, I'm sorry.
So,
10, correct.
12 and 10, they are in the custody of the,
Mother, man. Respondent mother.
even as on date of filing your petition.
Yes, my lord. My lord, after separation and before filing of all these petitions, many times, my lord, they visited Mangalore.
See, the purpose of your application itself is now frustrated.
Yes, my lord.
It becomes redundant now.
Correct.
Because your application IA 6 is filed for Christmas vacation.
No, up to 16th, my lord, there is vacation.
Christmas is over.
Up to
Sankranti
16th.
is coming.
Alala, that's true. Up to
Ah.
16th holidays are there for the.
Maybe whether the children are having holidays till,
16th, my lord. 16th of January.
but have you been given visitation rights?
No, my lord.
Where is that order?
My lord, no orders pending.
No orders are
Pending.
passed
No
even
orders are
for
passed.
visitation.
No, man.
You are appealing.
I undertake to file wakalat on behalf of the respondent, my lord. Their application itself, they have shared a copy through email. In the email, I could observe that they have not served the copies which are, the pages are jumbled up completely. I may not be able to read the papers in tact. And I could only see there, the date which they have asked is the vacation is going to be ended on 5/1/24. Maybe that might be a typographical error. They themselves have stated that the vacations are going to be ended on 5/1/25. So that is yesterday.
That will not change the fact. That, my lord, is the
Plus,
vacation.
I will file my objections, then we can have it for the hearing, my lords.
This application is filed when? This is filed on 15/11/24. For him for taking custody of the children. For both our parties are Christians.
No, my lord,
No,
both are Hindus.
Ah. And no order is passed even for visitation.
No, my lords.
Is there any other petition filed between the parties?
Yes,
There
my
are
lord.
other matters pending, my lords.
What is that?
DV and DV matter is pending, MC matter is pending, judicial separation and maintenance application is pending, my lords, before the family court itself.
Divorce is not filed.
Judicial separation is filed.
Judicial
So
separation.
you don't want to divorce your husband.
No, my lords.
You want judicial separation, you want maintenance,
Yes, my lords.
but you don't want to show the children.
We
And
are
two
allowing the
lakhs-
children to do the father. We have relevant documents to prove that we are allowing the father to meet the children at the house itself. We will file the details objections when the matter is given.
All this matter day after tomorrow, file
Please,
your
my lords.
objections.
Please, my lords.
And we have been paying 2 lakh maintenance per month.
Where is that order?
No, voluntarily we are paying in the DV.
They are
Act,
paying
my
once the
lord.
order is passed by the DV
Before,
court.
in the 125 CRPC petition. My lord, we have voluntarily given a state as a.
Not voluntarily, my
2
lord.
lakhs maintenance.
What
It's
is
not
your-
voluntarily.
What is your status?
I'm a businessman.
What about respondent?
Respondent is a housewife.
And where the children are studying?
They are studying in Canadian International School. Per annum, my lord, 12 lakhs is the fees that is taken care by my husband only.
We don't dispute that.
How much?
12 lakhs per annum in respect of one kid. So totally 24 lakhs per annum is spent by husband only.
Now children are having vacation.
Yes, my lord. Up to 16th.
To 16th, the children have vacation, but their application, they have not mentioned that also.
No,
And
is a
that is the
fact, my
reason
lord,
we,
which they
that is the
cannot
reason
dispute.
we want to file our details objection, my lords.
Children are with you.
Yes, my lords.
They are going to the school.
Yes, my lords.
So you don't know when the vacation is.
It is still the 16th, my lords.
And then what is the great dispute about the 5th or 16th?
No, the prayer itself, it'll get
Sir,
infectious, my
forget the
lords.
prayer. He wants to see his children.
Plus, it's not that I'm not allowing children to meet the
Bring
father,
them
my lords.
tomorrow. Bring them to the court.
Please, my lords.
Respondent, what's your name, sir?
Arpan B. Patan Shetty.
Learned Counsel Sri Arpan so and so appears and undertakes to file wakalat for respondent. He is directed to keep the respondent and the minor children present before the court at what time they can come? They are here in Bangalore?
Yes, my lords.
Keep them present at 11 AM before this court. And meanwhile, he is also permitted to file objections. You have given the copies, you have received copies?
Let's, the compliant office objections
copy I
copies may
will-
be served upon me, my lords.
Huh?
Office objection complaint matter, that copies he may have to serve it upon me.
No, the application which he is now insisting,
Yes, ma'am.
that is those IAs. 6, 7 and 8, those copies must have been served. to
Yes,
you.
yes, it is served upon me.
That is given in the family court itself.
Yes, ma'am.
What else you want?
The petition which they have filed before this honorable.
Yeah.
Yes.
You serve a
I'll
copy.
serve it right now.
Learned counsel for the petitioner to serve copy of the petition along with all documents during course of the day to the learned counsel for respondent. Objections, if any, to the application filed by the petitioner. Call on, day after tomorrow date.
Please.
Reply.
22 days.
Yes. IA 1 of 21 is allowed, delay of 72 days is condoned.
I will refer to local.
At request of both parties, matter is referred to Lok Adalat.
Yes.
Lakshmi Narayana,
The appellate delay of 412 days.
your claimant.
Claimants, my lord, case of death, my lord.
IA 1 of 21 is allowed, delay of 412 days is condoned, being satisfied with the reasons assigned and cause shown. Is this matter for admission? Twenty-four in time ತಗೊಂಡ್ರು. ರುದ್ರಪ್ಪ. This is IA. Recall application ಏನಿದು?
Not, could not comply with the office objections not earlier, not. The case has been dismissed for non-prosecution not.
ಯಾವಾಗ?
That's why I filed the application for recall.
26 June.
Please, my lord. 26 June, my lord.
Seven times.
Appellant is a minor, my lord.
Death case.
Death case, my lord. Appellant is a minor.
The objections.
Represented by.
What are the objections?
Objections are, some of the objections have been complied, my lord. I will comply with the remaining objections, my lord.
ಬರ್ಕೊಡಿ. IA number 1 and 2 are filed, seeking to condone the delay of 54 days in filing the application, to recall the order dated 26/6/24, and IA 2 to recall the order of dismissal dated 26/6/24. Please stop. I peruse the affidavit annexed to these applications, being satisfied with the reasons assigned and cause shown. These two applications are allowed. Delay of 54 days is condoned. Order dated 26/6/24 is hereby recalled. Petitioner is permitted, appellant is permitted to rectify the objections. 2 weeks' time is granted, subject to payment of cost of rupees 2,500 to the advocates within 2 weeks. Payment of cost would be a condition precedent. 2 weeks, you have to pay cost of 2,500, rectify objections.
Please, my lord. Similar, my lord.
Same order.
Obliged.
Had an application for substitute service, my lord. Respond number 1 is the owner of the vehicle. Liability fee on the owner of the vehicle, my lord.
Huh?
Trial court liability on the owner of the vehicle, my lord.
Liability.
Please,
Owner of the vehicle.
owner of the vehicle.
Your claimant.
I have the claimant now.
So here, before the tribunal, he was ex parte.
No, but ex parte. Sorry. Ex parte before the trial.
Maybe Tata AIG, you're appearing.
Yes.
Learned counsel for the petitioner has filed IA number 1 of 24 to take out notice to respondent number 1 by way of substituted service through newspaper publication in Hosa Diganta Kannada Daily Newspaper, Bangalore edition. Where is the affidavit? Memorandum of facts, not affidavit. Being satisfied with the same and service having not been complete by regular process, this application deserves to be allowed. Accordingly, it is allowed. The appellant is permitted to take out notice to respondent number 1 by newspaper publication in Hosa Diganta Kannada Daily Newspaper of Bangalore edition. The publication shall be taken out on
Please.
Delay of 46 days.
R2. Copy bandid R2.
We have filed wakalat, my lord.
You have received copy?
Please, my lord. HS Lingaraj filed wakalat.
All right. IA 1 of 23 allowed delay of 46 days is condoned. This for admission.
Kindly call for TCR.
Call for TCR,
Your
case of
records.
injury. Much obliged.
For appellant, my lord.
Weeks time may be granted, my lord. File wakalat.
For the second respondent.
Delay condone madam.
My-
IA 1 of 24 is allowed delay of 125 days is condoned. Learned counsels for respondent 2 and 4 are permitted to file wakalat. 2 weeks?
Please.
Fall
1
after
week,
2
1 week is.
Fall after a week. Date could.
Time for respondent.
In first case, 40 days delay in filing, my lord. In
Yes, D. Vijay Kumar, Pradeep. IA 1 of 24 is allowed delay of 47 days is condoned.
My lord, I am for the respondent, my lord.
then
In all these matters,
is
what about 30.1? No delay, is it?
30.1, delay already condoned. Then 3012, that I filed memo for a dispensation of my 1 and 2, 1 and 3. 3012,
Even 3012 andrenu.
memo filed for dispensation notice to R1 and 3.
30.2. Serial number
30.2.
30.2.
3012 andre writ petition number, MFA number.
Serial number.
30.1 and 30.2.
30.2. 30.2.
Memo for dispensation of notice to 1 and 3.
1 and 3, my.
There's no counter appeal,
No, my lord.
No.
can be dispensed.
Liability fixed against to the insurance company, respond number 2, liability fixed against.
They accepted the liability.
Yeah, accepted
Vijay
liability.
Kumar, client
Okay.
Vijay
Please,
Kumar.
my lord.
In fact, this matter was discussed in the Lok Adalat also, my lord, and
No, you, Mr. Vijay Kumar, you have not filed any appeal, Allah.
no, my, I have not filed any appeal.
All right, so we'll dispense notice. Notice
Yes,
can be
please.
notice
Please.
to R1 and 3 dispensed in 30.2.
And 47 days.
Delay of 47 days is condoned. IA 1 of 24 is allowed.
In this matter, my lord, TCR is necessary, my lord.
All right, secure records.
Please, my lord. Much obliged.
Call on.
TCR may be called.
Official date ಕೊಡ್ಬೇಕು ಇವಾಗ. We'll give date. And while giving, madam, while giving date, you space it in a manner and for you have to keep a monthly chart and give date. Don't put 150 cases one day. That's why you manage a calendar. At least their advocates will know when their case is coming up next. They don't have to go and beg the pending clerk. That is a problem.
I represent Gurudev Prasad Mele.
My lord, I appear for the respondent, my lord. Delay may kindly be condoned, my lord, and the interest may not be kindly be granted for the, during the period of delay.
Yes. Purple. Learned counsel for the appellant and respondent on IE 1 of 24. Delay of 245 days is condoned. IE 1 of 24 is allowed. However, appellant shall not be entitled to interest for the delayed period.
TCR may be called.
Secure records from the tribunal. Column. After 2 weeks or 3 weeks, you can give a date.
I have 188 days delay.
Jay Kumar, Mr. Vijay.
My lord,
Kumar,
I am for the respondent, my lord,
IE 1
respondent
of
number 2.
24 is allowed delay of
Without delay, without interest.
188 days. Delay is condoned. However, appellant
Minor
shall
may
not
not
be
delay.
entitled to
Interest cannot be denied, my
for
lord.
the delayed period.
Is minor.
Huh?
Is minor. Interest cannot be denied, my lord.
Minor. Huh?
Yes.
All right, we'll consider that. Now, what was he doing? Only one person is a minor.
Only one person is an injury case mad. Pritham.
No, this is represented by somebody or minor is now become.
Represented by somebody.
Represented by.
So why he cannot be denied? What was he doing?
No. Up to the age of 18 years, since he is a minor, under Section 6 of the Limitation Act, there is a limitation period will be extended. Therefore, interest cannot be denied.
And what do you say, Mr. Vijay Kumar?
Lord, when he is represented by the major person, natural guardian, my lord, he should have taken interest. Because of his lapse, my lord, insurance company should not be penalized.
Yes, no interest for the delayed period.
Legally speaking, it cannot be denied.
No, he may be minor.
No.
But he is represented by an adult.
Maybe under Section 6 of the Limitation Act.
Notice, read it.
I'm not expected this court will.
No, if you are convincing me, I will do so.
Yes.
Let us read Section 6.
Yes, Section 6.
Read it.
In all minor cases.
27.
Yes, continue. Next.
Records may be called for me.
Yes, secure records.
Much obliged.
Call. Wait, 20 seconds, sir. Nayak. Mr. Nayak. 100 IE 1 of 24 is allowed. Delay of 164 days is condoned.
Connected matter. Also
Other
connected.
matter?
Connected, one more matter is there.
One more connected matter, my lord.
Call this matter along with.
2062 of 2024, my lord.
Yes. Call on.
For the matter, local, both matters.
At request of both parties, matters referred to Lokadal.
Please.
Second respondent in this case, Your Lordship, but I have not been served with a copy of the appeal memo. Hence, I couldn't file my wakalat in this case.
All right, I'll grant you time.
They have to give copy of appeal memo to me, Your
All
Lordship.
right, he will give you.
Yes, Your Lordship.
Leonard, there's no representation on behalf of appellant. Copies of the appeal memo to be served along with IA to the learned counsel for respondent number 2. Call on. 310 days, Nagaraj.
36, yes, my lord, interest may be denied, my lord.
IE
Small
1 of
matter
24
only on
allowed.
the quantum,
Delay of 310 days condoned, however,
no interest.
claimant shall not be entitled to interest for the delayed period.
Only on quantum, my lord, disability certificate has not been produced, nor the doctor has been examined.
That list for admission. Please. Yes, a record is required.
Not necessary, my lord.
All right. Guru Prasad.
Appear for R1, my lord.
Hmm.
My lord, Sri P.B. Raju has not filed wakalat, my lord. The third copies, my lord, were sent to the company. Price weeks time, 2 weeks time, my lord.
IE 1 of 24 is allowed. Delay of 118 days is condoned. All this matter after 2 weeks.
Please.
Lingaraj. IE 1 of 24 is allowed. Delay of 20 days is condoned. Is for admission. Secure records. Beka records beka.
Negligence, contributed negligence is.
Beka. What is the?
I'm appearing for
tribunal-
appellant, madam.
Huh?
Appellant, madam. I'm appearing for appellant, madam.
Henry, what is the order passed by the tribunal?
They have not lead any evidence.
What is the order passed by the tribunal, sir?
Case for enhancement and negligence, madam.
Your claimant alwa.
Please, madam.
What is the order passed?
What was the insurance company is liable to pay the compensation? They say 20% negligence on the part of the petitioner.
Secure records.
Of 222 days, my lord. And I'm seeking for a stay. Facts are such that, my lord. And the respondent claims that she was traveling as a passenger in our bus in our bus. Subsequently, they claim that she met with an accident. She does not produce a ticket. The discharge summary is not produced, and she also claims that the document that she's relying upon with respect to the injury shows that it's only a CT scan that they've asked for, and because she was suffering from a headache. Whereas what she claims is that she suffered from a fracture, and then she has been awarded compensation of 2,08,000, which I'm challenging here, my lord.
Order learned counsel for the appellant on IE 1 of 24. A delay of 222 days is condoned.
Service cycle.
Maybe there is really.
Stay has not been granted.
Party served and unrepresented, Allah.
Served. They have taken steps. It's been served.
There shall be stay of operation and execution of the judgment and award dated 18/7/23 in MVC number 1869 of 19. Passed by the senior civil judge and MACT, Sakleshpura. To the appellant depositing 50% of the award amount within 4 weeks.
6 weeks, my lord.
6 weeks before the trial tribunal.
Please.
For the tribunal.
For the appellant in this matter, my lord.
I am for respondent 1 to 4, my lord. We have filed a withdraw, IA for withdrawal amount, my lord.
Lord.
Kindly permit to withdraw the amount, my lord.
Appeal by the
death case.
insurer, my lord. The challenging that there is no nexus to the death and accidental injuries, my lord. So
death,
TCR may be called for, my lord.
Due to accidental injuries, my lord. So kindly
Stay is granted, is it?
A stay is granted, my lord. I have deposited, my lord. I have not filed the acknowledgement. I have the copy of the for depositing.
What is your defense?
that there is no nexus to the accidental injuries and the death, my lord. My lord, as per the wound certificate and the injuries, my lord, he has suffered evolution of skin 2 into 2 centimeters right upper cheek area, abrasion of liner 4 centimeter long of lower cheek area, external rotating of left leg with respect of knee joint, and abrasion on the left knee. My lord, as per the post-mortem report, my lord, the deceased Villappa was brought dead to the Victoria Hospital, and the PM report does not disclose the exact cause of the death. Further, the histopathology report finding at impressing lungs shows features of aspiration phenomena, liver shows feathering, cysterious heart shows feathering of coronia arteria disease, which relates to heart, my lord. This is what we have challenged. My lord, the date of accident is, my lord, 9/6/2017, my lord. The death is on 8/10/2017. After the accident, he has taken treatment and he was discharged, my lord. These are our contention.
So 9/6/2017, he was admitted till when?
Till 26/7/2017, my lord.
You filed your objections to the application for withdrawal?
I'll file, my lord, 2 weeks time. Meantime, LCR may be called for, my lord.
So kindly allow
Oh.
my
File your objections.
50%.
What is this IA3 for paper publication?
And last, my lord, there is a court direction to file a paper publication in respect of R5. It was unclaimed, my lord.
Who's R5?
R5 is the owner of the two-wheeler, my lord.
My lord,
Insured vehicle.
wife and children is there, my lord. So kindly.
1 to 4 are the
permit
wife and children.
Withdraw the amount, my lord, 50%.
He is disputing the entire, the reasons assigned by the trial tribunal. He says there is no nexus with the injury and the accident. So let him file objections. Paper publication is taken up or not taken?
Not taken, my lord. Last time it was unclaimed, my lord.
No, now R5. is-
I'll take paper publication.
Who's R5?
Owner of the insured vehicle. It by two-wheeler, my lord.
It is your two-wheeler.
Please, ma'am.
So liability is fixed on you. Insurance is there.
Insurance is.
What is the need?
If I succeed, oh, please, my lord.
No. Are you saying that there is no insurance?
It's there. ma'am.
Then what is the need for R5?
I'll not press, ma'am.
Learned counsel for the appellant seeks time to file objections to IA number 2. Call this matter after 2 weeks.
Please.
For appellant in this case, my lord. In 41.1, kindly delay may be condoned and notice to R2 may be issued, my lord. R2 is insurance company, my lord.
So insurance company is R2 in first and second case, both.
Please.
Yes,
In
my
this,
lord.
My lord. In Krishnaswamy has filed wakalat, my lord. Sri P.B. Raju name may be deleted, my lord.
IA 1 of 24 is allowed. Delay of 68 days in filing the appeal is condoned. You are for claimant?
Yes, my lord.
Same order in the next case, madam. 42.1. IA 1 of 24, 69 days. Registry to delete the name of learned counsel P.B. Raju for R2 and retain the name of learned counsel A.N. Krishnaswamy for R2 in both the cases. Wakalat to be filed by learned counsel Sri A.N. Krishnaswamy for R2 in both the cases. Call on.
My lord, case has been dismissed in trial court, my lord. Kindly TCR may be called for.
It was dismissed, is it?
Yes, my lord.
Secure records.
Much obliged.
For respondent, my lord. I have filed IA for vacating the stay, my lord.
Petitioner, your lordship.
Hmm.
Lordship, I had produced a memo. So the petitioner is a dentist. The respondent is also a dentist. Your lordship, the impugned order is an order granting maintenance to the wife respondent. I had produced a memo which has documents showing that the wife is in possession of my dental clinic. And that is my only source of income. Therefore, I have nothing to sustain myself, let alone provide anything for the wife. There are documents that are produced to show that she's in the clinic, she's giving out prescriptions. And the board also has been changed to her name, the clinic which was mine originally. Therefore, on such submission, this honorable court was pleased to grant an interim order, staying the order of providing maintenance because I do not have my income of my own.
Where is that order?
Your Lordship, 27/2023 is the interim order.
No, what is the order of the trial court impugned?
Yeah, yes, Your Lordship.
8,000 per month.
Yes, Your
My
Lordship.
lord, and 5,000 litigation expenses.
Hmm.
My lord, I have filed a statement of objections, my lord. Your lordship may kindly see the documents, my lord. My lord, she is taking treatment for neurological problem, my lord. I have produced the documents that she is taking treatment from Manipal Hospital, my lord. Annexure R2 and R3, my lord.
Madam, for your neurological problem, you're taking treatment?
Allah, my lord, your lordship may kindly see that she has not renewed her license because of her problem, and she is doing LLB. She quit her profession. Annexure R3 is the document, my lord, certificate issued by the DHO stating that Dr. Seema TJ ಇವರ ಹೆಸರಿನಲ್ಲಿ ಡೆಂಟಲ್ ಕೇರ್ ಎಂಬ ಸಂಸ್ಥೆ ನೋಂದಣಿಯಾಗಿದ್ದು ದಿನಾಂಕ 4/3/18 ಮುಕ್ತಾಯಗೊಂಡಿರುತ್ತದೆ. She has not renewed her license because of the neurological problem. She cannot hold the instruments and she cannot stand for a long time. My lord, I have produced this honorable court, my lord, directed me to file the affidavit that she quit her profession and doing LLB. I have produced the affidavit, my lord, on 14/8/24. I produced the affidavit and along with the documents which shows that, my lord, she has produced a identity card of RL Law College, Davangere, and 23/24. She has passed her first and second sem. I have produced the marks card also, my lord. Karnataka State Law University, RL Law College, June 2023. She passed her first semester and she is pursuing her LLB. I produced the identity card also. And my lord, the Banashankar in Lia, I produced the photographs of the clinic, my lord. The clinic is, my lord, now demolished. It was in rented building, my lord. It is demolished and she is not doing any practice. Banashankar in Lia, the document, my lord, along with my affidavit, I have produced the document.
Yes.
At page number 5 and 6, my lord. The photographs, it is demolished. I am not practicing, my lord. The document produced by the prescription produced by the petitioner is, my lord, it is the one person who was taking treatment while she was practicing. Now, my lord, she is doing LLB and he called her, my lord, and informed her that he took treatment, it is cured. That is why he want the same prescription. That is why she issued only prescription. Even though she denied, he came to her house and, my lord, she issued the prescription only. In the affidavit, I have stated it. Your lordship may kindly see the affidavit, my lord. Affidavit, the second.
But I will hear you.
Pardon me?
I will hear both of you on
Yes,
the
sir.
main matter itself. What is the order now passed? That is stayed. The impugned order is stayed.
Yes, Your Lordship.
So now you're seeking vacating that order, na?
Yes, my lord, I want to stay because, my lord.
What is the status of the matter before the?
Now, my lord, it is posted for evidence. He has led evidence. Even without giving any maintenance, my lord, he is leading with the divorce petition filed by him.
I don't, because it is.
Because of the stay order, my lord, he is not giving any maintenance.
Yes.
The arrears is now, my lord, 4,60,000. Since from the date of petition, my lord. Your lordship may kindly see the order passed by the trial court, my lord. It is unequivocally, my lord, it is stated by the trial court, my lord. The impugned order at paragraph number.
Order illa madu. Take out that order.
Paragraph number 8, my lord. The petitioner has filed the petition against the respondent seeking maintenance. The third line, my lord, from the bottom on page number 4 of the impugned order. The counsel for the respondent has filed copies of the notices issued by the health department to the respondent, reply given by the respondent and her health records. On perusal of the same, it appears that the health department has rejected her application for opening of dental clinic. Further, a notice is also issued to her. In spite of expiry of period, she has not renewed the license.
Madam,
But-
according to you, your husband is running a dental clinic?
Miss Millard, he is running a clinic, he is owning a gym, he's running a gym and he is a model, he's doing modeling. And my lord, in the affidavit of the assets and liabilities, I have stated, he is having income of 85,000 rupees per month, my lord.
So both of you are dental doctors and both of you are not doing dental work.
No,
He's running his dental clinic, my lord, but
And-
he has stopped
Where?
in Davangere only.
that clinic.
The material.
Material, my lord, I can take the photographs only, my lord.
Yes,
On the date of filing
Have
of
you
the
filed
petition.
your assets and liabilities?
we have not filed, Your Lordship.
File it. File it, I'll consider and dispose of the main
But
petition.
last time she was also directed to produce the assets and liabilities.
I'll
Instead of
produce-
that, she has not. But I have produced the assets and
You have
liabilities.
filed,
I filed it.
you have filed,
We file, Your Lordship, whenever on the next day.
all right. Markali, both learned counsel for the petitioner to file the assets and liabilities. List this matter after 2 weeks.
Right, a short date may be given, my lord, because he is proceeding with the case, my lord. And
Yeah,
cross,
go ahead with the case. What is stopping you? No, he has filed the petition.
he has filed the petition for divorce.
All right,
He's
you want,
proceeding with
you
the
want, you
case.
don't want to give divorce. You don't want to accept for divorce. You want to live with your husband.
No, my lord, she can also accept, but my lord, the maintenance amount can be given.
Madam, now the petition is for divorce
Yes, my
filed
lord.
by the husband against you.
Yes,
Whether you want to live with your husband,
she has contested, my lord. She want to live
have
with
you filed
husband.
any counter or are you only defending it?
She is defending it.
Only defending it.
Yes, my lord.
So you have not filed section 9.
No, my
You
lord.
have not filed any counter.
No.
So you don't have a stand.
She filed objections for the divorce.
Whether you want to live with your husband or you don't want your husband, simple.
The relationship is now strained, my lord.
Correct.
I think she is not ready to
2019.
live with her husband and he is not ready to take her. If he is not ready to take her, how can she live with her husband, my lord? He is not ready to take her back.
So he is the one who's come before the court for divorce.
Yes,
He is not fickle-minded. He has put his stand that he doesn't want you.
yes.
You have to put your stand, whether you want to live with him or you want to separate. That is on divorce. Maintenance, of course, that will run. You go on with your MC case. Let that come to a final outcome. This will decide on your maintenance. What is there?
Yes, my lord, because of the strained relationship and he is not ready to take her back, she also, my lord, ready for divorce.
And go and file mutual consent and we'll decide this later. Why you want
But the
to?
maintenance can be given, my lord. If she gives the maintenance, he gives the maintenance and the same case can be proceeded with and my lord, it can be
Will
closed.
pass such an order. I will direct the family court to decide on the permanent alimony and decide this matter. Now you can either file a mutual consent or you can agree.
My lord, whatever are the amount outstanding, he can give that amount. And my lord, thereafter, my lord, the permanent alimony can be fixed, my lord, in the same petition.
Yes, what's the difficulty?
This is new that they are saying that we will, this whole question about divorce has never come that they'll agree for a mutual consent.
Madam, now you have to see how you can proceed further in life. Don't waste your time in family court. Now you are filed for divorce.
Yes.
Both of you are doctors.
Yes.
Both of you are not pursuing medical profession.
No, I am a dentist, but she's in occupation of my clinic. That is
Are
my
you running a
submission.
dental clinic or running a gym?
No, I am not. I am running a dental clinic. It's her claim.
Where
that
are you?
I'm running a gym.
You forget about her claim. You tell me your claim. What are you?
Yes, Your Lordship.
Where are you running your dental clinic?
Same dental clinic in which she is practicing was my clinic. And now she has changed the boards and is giving,
When? From when?
Your Lordship, post the grant of maintenance also, 21/12/23. The order of the interim order of the impugned order is prior to that.
So if she is taken over your clinic,
Yes.
where are you
No,
running your
I do
clinic?
not have an income as of now.
Madam, if she is taken over your clinic, according to you,
Yes, Your
paying
Lordship.
the board, What are you doing?
I am not practicing. That is my whole.
What are you doing? You're not practicing. What are you doing for your living? You don't eat.
Yes, Your Lordship, all my savings or something I've derived from.
Put it in writing. Put it in writing. File an affidavit of undertaking.
Yes,
File your assets and liabilities.
yes, yes.
You proceed further in the divorce case. If you want to decide mutually, you say no objection. We'll pass an order on deciding the permanent alimony. Despite this, it can continue.
Yes,
You
if
still
the,
have options even after that.
yes, my lord. If the outstanding amount is given, my lord, I can proceed with the.
All right, I'll decide this matter after 2 weeks.
Please.
Let her file her affidavit, assets and liabilities. Meanwhile, you also secure what he's doing. Both of you are income tax assessees.
She is not an income tax assessee, my lord.
She is not.
She is
You
not.
are income tax assessee.
Sure. He
You
would
will be. You can't be income tax. You don't hold a PAN number. You file your
Yes,
assessment. You file your tax returns.
yes.
Call this petitioner to file assets and liabilities, including income tax returns, ITR for the previous 5 years. Are you holding PAN?
Pardon?
Are you holding a PAN number?
No, my lord, she is not.
So also the respondent to file, if any. Call
Please.
this matter after 2 weeks on. Both the parties are at liberty to proceed further in the matter pending before the family court. You proceed further in that, madam.
But-
You will be benefited, both of you. Why you want to waste your life in the court?
If the outstanding amount is given, my lord, I
That
have
anyway,
no
this
problem.
court will decide, madam. If she loses, the husband loses this petition,
Yes.
8,000 in maintenance is there. Whether he doesn't lose, you will still have a remedy to recover or file one more petition. Other than this, or even in the permanent alimony, in your MC case itself.
That again takes time, my lord, for deciding the case and all. If this.
No, it will not
interim
take time.
order, if this is interim order, if the
It's up to
outstanding.
you. I call the next case.
Appearing for respondent in this case.
I appear for the petitioner husband, my lords. Before I get into the merits of the case, I must point out a couple of things, my lords. There's a default on my part. Previous order, my lords, there was an undertaking given that 2 lakh would be deposited. Petitioner was not able to do it because he had to dissolve his assets, which did not come through. With that, my lords, a brief outline is that the petitioner husband is before this honorable court seeking modification of the order granting interim maintenance. Interim maintenance awarded is 50,000. I am seeking a modification of that order, my lords. I am not running away or shying away from my liability.
Where is the impugned order?
My lords, Annexure G, page 98 to 101.
Your Lordship, there is an interim order of this honorable court on dated 10/9/2024, directing the petitioner to pay 9.7 lakhs, about 30% per month arrears until the date of 5/9/2024, which he has not paid till today, Your Lordship. Wherein the entire arrears shall be cleared and the amount shall be paid by 24/9. And the amount, if not paid, appropriate orders will be passed because he has committed perjury in his affidavit, which was filed in another court. Because in the family court, the petitioner did not file his assets and liability affidavit. And the orders were passed on 14/6/2024, 23. Wherein much before that, in March 2024, the petitioner had filed an assets and liability affidavit in the domestic violence case.
My lords, if
And
it is
he
being
has
heard on
made,
merits, I am ready, my lords. I'll begin.
And there is an interim order passed by this honorable court, which he has not complained till today, keeping on taking time. And even on 13/12, before Christmas, there is a wife and 2 children. I'm appearing for the wife. And he was not paying any maintenance until the matter reached this honorable court. And after coming here, this honorable court directed and they made a payment of 3.4 lakhs, 4.5 lakhs. And he was directed to pay. They took the instructions. And this is
When was the interim order passed?
10/9/2024, Your Lordship.
My lords, there are 2 orders. 29/7/2024 may be kindly perused for a moment. 29/7/2024, my lords.
Yes.
this honorable court was pleased in the last portion, I'm only reading the operating portion, my lords. Considering the fact that so far wife has not received any amount, husband shall pay at 30,000 per month as arrears from the date of petition till today, and demand draft shall be placed before this court on 21/8/2024. Thereafter, my lords.
Read that again.
My lords.
Read that again.
Yes, my lords. So far, wife has not received any amount. The husband shall pay 30,000 per month as arrears from the date of petition till today, and demand draft shall be placed before this court by 21/8/2024, my lords. Next, my lords, on 10/9/2024, the petitioner, 10/9/2024, my lords. Today, learned counsel appearing for the petitioner has handed over a demand draft of 3 lakh to the learned counsel appearing for the respondent wife. It appears that he has paid an amount of 50,000 in the execution, and the remaining amount, there's an execution proceedings pending, my lords. The remaining amount calculated at 30,000 per month from the date of petition till this month, 5/9/2024. The entire arrears shall be cleared, and the amount shall be paid by 24/9/2024. If the amount is not paid by 24/9/2024, appropriate orders will be passed. Then thereafter, my lords, kindly peruse order dated 15/11/2024. Learned counsel for the petitioner on instruction submits that the petitioner is ready to pay a sum of 1 lakh during the course of the day. This was later on paid on the very same day, my lords. There is no quarrel on that aspect as well. Now the standing is that, my lords, as on this day, January 2025, the arrears at the rate of 30,000 would amount to 11,10,000, my lords, of which 4,50,000 he has deposited on the previous occasion. The difficulty now is that he is a freelance music teacher earning approximately around 90,000 a month. The respondent wife in her affidavit of assets and liabilities claims that she is earning at about 61,000 as on the date of application, which is in 2021. This being the factual background, I have been asked to pay interim maintenance of 50,000 a month. My grievance is that a freelance music teacher having other liabilities to take care of his mother and EMI and other expenditures is not able to pay 50,000 at the rate of 50,000. That is my case which I have put forward. Although I agree that there are orders passed against me, directing me to pay the arrears. The petitioner is unable to do it because he was unable to liquidate his assets. He was trying to sell off his property, which did not come through in the last minute.
Your
Therefore, just a minute.
Yes.
Therefore, under this background, my lords, I am here before my lords today. I am willing to take any orders which my lords pass because I am at default on this aspect. Apart from that, I am ready on merits. If my lords are willing to hear the matter on merits, I'll just place 4 points of my.
Your lordship, till today, the arrears is 18.5 lakhs.
That is
The
at the rate
order is to
50,000.
pay the arrears from the date, the petition is filed in 2021. He had deserted it around 2019, he had deserted her. From then till today, he is not taking care of the wife and the 2 children who is school going, and she is giving good education, and she does not have a house also to stay. She is living in the free accommodation of a church. She wants a house to be taken for rent. She has to take care of the 2 children. Your lordship, he has not filed his assets and liability affidavits in the family court, in spite of the fact that he had filed it in the domestic violence court much before the orders being passed in the family court. Your lordship, I have produced 1 copy of his assets and liability affidavit along with my objections which he had filed in the DV case. Wherein your lordship, in page number 12 of my objection I have filed, he says that there are general monthly expenses of the applicant. He wants 80,000 for his expenses. And for his dependent, his mother, he wants 20,000. Your lordship, and also he's telling that he is having music classes, monthly income is 1,20,000 in page number 15. Your lordship, coming further ahead in page number 18, he says he is currently employed and the latest income in foreign currency is 4,150 AED, that is 91,000 in Indian currencies. Altogether, it comes nearly 2,11,000. It is his own assets and liability affidavit.
My lords, it cannot
which
be
he filed,
added in that fashion.
kindly allow.
I'm sorry. I'm sorry.
Which he filed in the domestic violence case on 14/3/2023. And the orders in the family court is being passed in 14/6/2023. Even then, he did not file over there. Your lordship, in my, and meanwhile, on 27/5/2022, he filed a petition for the child custody. Even the copy of the petition also I have filed along with my objections. In page number 23 of his child custody petition, your lordship, in paragraph 15, he has submitted that the petitioner is working at Dubai and earning good salary to take care of both the minors, wherein now in the present writ petition, they are telling that he has lost his job. He is not working. It is a petition filed in 2022 for the child custody. And when the maintenance was ordered, immediately he doesn't want to take care of the wife and children. He was not even taking care, and he did not even pay a single penny until he reached this honorable court, my lords. And till today, they were taking time in spite of the orders passed by this honorable court on 24/9/2024. Till today, they are taking time. And here, at that time, they were supposed to pay 9.7 lakhs. To hear their petition, there was an interim order passed by this honorable court. Even now, they are
The
taking
arrears
time.
now, as of now, what is the arrears?
Arrears till today, it is 18.5 at the rate of 50,000. And according to the interim orders, he was supposed to pay
11.1 is to be paid as per the interim orders.
Interim
my lords,
orders.
Of which 450 is paid.
Only
660
4.5 lakhs has
So
been
that
given.
interim order of which date?
24/9/2024. Sorry, lots.
my lords, the first interim order is
Yes,
29/7/2024.
On 29/2024,
That is
it has been
where the
mentioned.
first time 30,000 at the rate of 30,000 per month was ordered. Thereafter, a demand draft of 3 lakh was handed over.
It's
1 lakh
clearly-
was transferred.
Clearly
50,000
mentioned in
was
10/9/2024.
That being the case, 4 lakh 50 is already transferred. 6 lakh 60 is the arrears as per going by the order of this.
As of now, there is no stay of this impugned order.
There's no stay, my lords, but then the interim order states that 30,000 per month. Even then, the arrears is around 6 lakh 60,000, my lords.
Where does the interim order say 30,000 per month?
My lords, kindly have 29/7/2024, my lords.
To hear their petition.
The
honorable
last
court-
portion, learned counsel for the petitioner submits that he is not in a position to pay 50,000 as ordered by the court when specifically court had inquired about the arrears. Considering the fact that so far the wife has not received, the husband shall pay 30,000 per month as arrears from date of petition till day. That was the first order, my lords. And thereafter, on 10/9/2024, my lords,
All right, at the rate of 30,000 per month, what is the arrears?
6
at
lakh
the-
60,000.
This honorable court had ordered to pay till 5/9/2024 at the rate of 30,000.
Rate
That
of
was
the-
9.7 lakhs, of which only 4.5 has been paid.
Pay
till
the
today.
balance arrears.
I understand. my
And
lords.
they
My,
keep-
my difficulty is that I am a freelance music teacher earning about 90,000 a month. I have EMIs to pay off. And even after that, 50,000 per month, I'm unable to pay the respondent wife. That apart, my lords, a huge lump sum amount of 6 lakh 60,000, I'm unable to liquidize my assets as of now. And therefore, I'm not able to pay it at one single stretch, my lords. I'm not shying away from my
But how
responsibility.
much, what is the time period you want to pay?
My lords, he is saying it, on instructions I submit, my lords, he's saying another 5 months for the entire 6 lakh 60,000, my lords. But then I did deliberate because there was an order passed, and on the previous occasion, he had only undertaken to pay a 2 lakh amount. But then that sale did not go through. That sale
So
did
now
not go through.
Your lord- She is not able to live, your lordship. She is
My lord-
present here petitioner. She has 2 grown-up children and studying in
What
the
is your client doing?
your lordship.
What is the respondent doing, madam?
She is doing a consignment company. She is doing a job night shift she is doing. And her assets and liability we filed in the family court.
Well,
All
just-
right, it is
And-
not-
just for a
And
moment, ma'am.
she doesn't have a house also, your lordship, and the school expenses, the 2 children's expenses. And based on which, and he claimed that he has good salary in the family court, but he was not willing to pay his assets and liability affidavit. Under the circumstances, he doesn't pay the assets and liability affidavit. After so much of opportunities also being given, the family court had taken into consideration her affidavit and her statement and had awarded 20,000 to the petitioner.
What
That
is your salary, madam?
60,000, including
You-
everything, it is
So
60.
you are unable to live With earning 60,000, you are unable
Your
to
lordship, I don't have a house. I want to take a house for rent.
take a rented house.
Rented house, minimum it costs 35,000, your lordship.
Won't take it
And
till the he's anyway
money
paying.
is not given.
Huh?
He has not paid anything till today.
Pay now at the rate of 30,000, he will pay.
They are not paying. They are not
Expect him
paying.
to pay, madam.
From 21 till today, she has
Paid.
borrowed money from others and has lived. Now they are paying in 2020 for 4.5 lakhs in several installments he paid. Now again for Christmas also, before Christmas, there was an order by this honorable court to pay 1 lakh. They did not pay. And she's borrowing from others and doing everything. She's spending everything on the children and also even to live there in the church account. They're asking her to go out of the premises. She had taken a short time permission. Now they are asking she cannot live continuously in the church premises.
My lords, just for a moment, just wanting to hand over a memo, my
And
lords.
she wants minimum 50,000 for that alone for the
Who has
children.
filed this petition for divorce?
Yes, your lordship.
Who has filed the petition for
She
divorce?
has filed the petition for divorce.
What grounds?
Cruelty, your lordship. He had thrown her out while they were living in Dubai out of their house and he was not taking care of her and children. She had to come to India, take refuge, take shelter in the parents' house and her father is a priest. So there in the premises, she has taken the temporary shelter and she has to live any time with the children. She cannot live with the children over there.
My lords,
How old are the children?
Children are 12 and 13, your lordship.
just for a moment, there are 6 cases
And-
pending between the parties. I'm wanting to file a memo to
And
bring the
he's-
present
he-
status on record.
He is living with another lady in Dubai, your lordship, and there is for bigamy also the charges are there on him. And he is still living with her. And he is not taking care of her and not even paying the maintenance or the school education fee, the
Just for a
house
moment.
rent. He doesn't know the wife and the children and he is not even ready
lords,
to obey
initially-
the orders of the honorable court also.
Initially, a criminal miscellaneous petition is filed against me, seeking 1.36 crores as monetary relief and 2 crores as compensation with maintenance at the rate of 98,800. The prayers of that petition is at 8 of the memo, my lords, what I've submitted to the
She
court.
was even ready to settle
Just-
for a small amount also,
just-
your lordship. But he was
Just for a
not
moment,
ready.
madam, just. And thereafter, my lords, MC 5951 came to be filed by her. Even here, 1 crore alimony. These are all parallel proceedings, my lords. The cases are all going together. The divorce petition, the prayer is dissolution of marriage, 1 crore alimony, 98,000 per month as maintenance. That apart, I have filed MC 6388 of 23, which is still pending. That is for restitution, my lords. And that apart, GNWC seeking children's custody. Although there are interim orders, I have not been given access to even video call my children, my lords. That I'll not get into that aspect because the scope of the present petition is limited to the interim maintenance.
What happened to your restitution petition?
My lords, that is still pending, my lords.
It's
It is-
clubbed with the MC and
is-
it is in the stage, at
next
the
date
stage of
is-
evidence.
Next date is 1/2/2025 for cross-examination of witness.
Here the
I am to
petition
examine
husband,
her.
in his child custody petition, since several times, he is not even appearing in the court to lead his own evidence. In his own petition for child custody, he is not participating, he is not leading evidence. He is filing all these only to frustrate her and he's
So you
not
want to
settling.
take your wife back?
My lords, yes, my lords, I am willing to take.
Are you ready to go and join?
No, your lordship, because she was thrown out on the roads of Dubai and she was living in a PG and the children were outside. Children also was under trauma and the children told it in the family court. We were thrown on the streets by our father, the children told.
Write down. You pay the arrears.
Certainly, my lords.
By order dated 29/7/2024. This court directed the petitioner husband to pay 30,000 per month. From the date of petition till realization. The petitioner has paid part amount
of 4,50,000,
of rupees 4,50,000.
50,000,
There is arrears of
6,60,000
For the
remaining
interim order,
at the rate of
6.7 lakhs.
lakh
For
60,000 at the rate of 30,000 per month
lakh 60,000 as on today.
as on today.
6.7, your lordship. 6.7 lakhs
6.7 lakhs as on today. The
as per
petitioner
the interim order.
shall continue to pay this amount of interim maintenance at the rate of 30,000 per month and clear all the arrears of balance amount of 6.70, 6.70,000, 6,70,000.
Your lordship, it is only the interim order to hear the writ petition up to the date of 5/9/2024. The arrear is exactly 18.5 lakhs.
This court has already modified that.
No, no,
By
your
virtue of an
lordship,
interim
the
order.
fine, it is not heard yet. It is
Alright,
not
This is
heard.
an interim measure.
Interim.
Shall pay the balance arrears amount of 6,70,000 in 3 installments within a period of 3 months from today.
Now till date, it will be more than that. It was till November.
That's why I asked you whether.
My lords, I have
6.70
calculated until January 2025, it is 11,10,000, of
That
which
must be-
4,50,000 is paid.
Calculate.
Yes, this was 5/9. I calculated 6.7. He must be right. 11.5 it will.
So 6.70 lakhs as on today.
6.7 plus.
As on this
The
date.
next 3 months,
Arrears
as on
is-
till, yeah.
My
till
lords,
today.
the application date is November 2021.
All right.
Yes, till today. He's
Arrears within 3 months from today.
11.5.
If the amount is not paid, respondent would be at liberty to execute the order. All right,
Execution proceedings are already.
all right, you
going,
continue.
But there also arrest warrant has been issued to the petitioner husband. He's absconding. He will not come to the court. He will not lead his
I'm
own
staying
evidence.
this order. Work only, there shall be stay of the order. Impugned order, subject to payment as ordered herein today. You can't execute and arrest him and also take money, madam.
Your lordship,
you take
your
money.
lordship, nobody is going to arrest him.
So what's the purpose?
We are not.
Are you interested in putting him behind bars or you want money?
No, your lordship, she wants even to settle the matter. She even talked with him. And she even talked with him, but he is not even ready to pay.
I'll refer you to mediation, go and talk.
They talked once, twice, and now what's
File for divorce.
Yes, your lordship.
He has filed for
Yes,
restitution.
your lordship.
Restitution doesn't make any sense because
Yes,
he
your
doesn't want to
lordship.
go.
Yes.
There are children. So you want to part ways. You part ways, agree on some amount. Even if you don't want to agree on some amount, that option is already open for you to litigate. If you want to litigate the rest of your life, you can litigate.
No, your lordship, she wants to put an end to all the
That
cases.
is why the best method for you is you go on with this divorce matter, enter into some logical conclusion, fight for your maintenance, whatever is you are entitled to.
She
And then
had-
in the meanwhile, you sit for mediation, sit across the table. Then you can save your time. How old is she now?
She's 39.
Then
Your
how long
lordship,
you want to go on and whether
your
what is his
lordship,
age?
she's ready for a talk
42 years.
outside.
43 now, my lords.
43 years and she's 36 years. You have to put an end and move forward in life.
Your lordship, but he doesn't come forward for a
We'll
proper
ask him
talk.
to come
I
forward
will
now.
certainly, my lords, the problem
Sorry.
is one or the other arrest
Stay
warrants.
Stay of the impugned order subject to making.
Your
the
lordship,
payment.
it may not,
1
stay
minute.
may not be given your.
Huh?
Stay may not be given because then they will not
Subject
pay
to
even one
payment.
single
Madam, it is
penny at all.
subject to.
Yes, sir.
If he doesn't, that's why I have already ordered.
Yes, sir.
If he doesn't pay, you continue with your execution. If he doesn't pay this within 3 months,
Yes, your
you continue with your execution. In the meanwhile, parties are directed to appear before the Bangalore Mediation Center. Your party is here in India?
No, my lords, I'll ask him to
He's
lie down. Dubai, my lords.
Dubai.
Tell him to come. When can he come?
My lords, any date on a weekend, my lords, on a Saturday, he'll be here.
Take a date.
My lords, 1st of February, my lords.
That is not a working day. Is it working day
It's a first Saturday, my lords.
for the mediation center? Party, in the meanwhile, party shall appear before the Bangalore Mediation Center Karnataka, no? Karnataka Mediation Center. Karnataka Mediation. Huh? It's called Karnataka Mediation. Karnataka Mediation Center at Bengaluru on 1st February. Without awaiting for any further notice from either this court or the family court. And the party shall try to resolve the dispute amicably. All right?
My lords,
1st February.
But some amount may be paid, your lordship.
I have already ordered that he will pay this within 3 months. If he wants to pay entire amount in this next 2 days, it is for him. If he wants to pay it in a phased manner, it is for him to pay. If he doesn't pay, then you are entitled to go and execute the order.
Your lordship.
As of now, you are working and earning. It is not that you are going to be in penury.
Your lordship, out of the 60,000, the entire money will not come to her hand. They'll have some.
All right, this court has not curtailed any of your freedom of getting your money.
Yes,
You will
your
get it in these 3 months. Meanwhile, you explore possibility.
Yes, your.
If that is only an interim measure.
Yes, your lordship.
If he doesn't succeed, then that amount of whatever ordered by the trial court, family court will continue.
Yes, your lordship. Yes.
my lords, there's one apprehension, my lords. There are warrants issued against me. If I'm participating in the mediation physically, that gets executed, I may be at,
Which warrant?
my lords, the executing court had issued a warrant, my lords. I'll have to
Have you
see.
challenged that?
No, my lords.
They have not challenged. They are not
I've
participating
challenged
also.
That is for you to challenge it.
They have filed a
I certainly
wakalat.
understand, my
They
lords,
filed a wakalat, but after that, again, they are not coming. They are not ready to pay even one single penny. They say that we have.
Get that also file for challenge that.
certainly, my lords.
And but anyway, you appear, even if you can't come or send a GPA holder or appear online.
Sure, sure.
Your
On-
lordship,
online
while
liberty may be
FIR court
granted.
also, in the CC matter also, he is not appearing. He's really completely absconding from the cases and from all the matters
Which
related.
case?
In the CC matter, there is an FIR pending against him for domestic violence.
How he can come to India, madam? You'll catch him by his.
Your
neck.
lordship, the arrest warrant is very recent.
Maybe.
Till
now,
today, it was not
please
there.
understand. If you file cases against the husband or any person, he will not come into this country.
That is only recently. Till today, he did not.
The recently or
2020.
future or past doesn't make sense, madam. You have to be act.
Even she is not.
Logically, you have to act.
Even she is not intending to harm him or she
So
wants to
that
settle
is
it
why you sit
amicably.
across and tell him,
Certainly.
you don't precipitate, he will appear, Varkoliman. A petitioner is permitted to appear in the mediation through video conferencing. If
Yes.
there is a threat of arrest.
Much obliged.
Yes,
So you initiate a process to put an end to the solution. Unless you resolve that, you are stuck in this litigation.
nobody is pressuring, giving pressure on the arrest warrant or anything in the family court also.
He will be under threat.
But till today, he was not coming, he was not doing
He
anything.
will not
and
come,
so-
I am telling you.
No, even
I
prior
will
to that
participate in the
also, prior
proceedings.
to that, from 21,
I
he
will
was not
participate.
doing, he was not paying anything, he was not coming.
Now we have put him to
Execution
terms.
proceeding started only in 23.
Now this court has
and-
put him to terms.
Yes,
So you are also benefited, he is also benefited.
Your Lordship, we
So
will
keep
see.
an open mind, tell your client, you tell your client
Certainly, my lords.
to
I
pay
will.
the amount. If not for her, you deposit a lump sum amount for your children.
Sure,
You
certainly, my
Only
lords.
divorce
And
your
I'm-
wife, not your children.
Certainly, my lords. Much
All
obliged.
this matter,
Much
give a
obliged.
date. Give a date after, in this month only. On 27th, you are supposed to show some deposit
Sure,
made to her.
certainly,
She has
certainly,
to feed her children, send her to school.
certainly, my lords.
Hmm.
Much obliged.
much obliged.
Very propellant, my lords. Kindly 1 week time may be given, my lords. ಇದರಲ್ಲಿ TCR records ಸ್ವಲ್ಪ ಬೇಕಿತ್ತು. Because income is wrongly taken, my lords.
TCR ಇದೆಯಲ್ಲ.
ಅಲ್ಲ, ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ, my lords. ಅದನ್ನ secure ಮಾಡಿ ನೀವು.
Counsel for the appellant seeks time, call this matter on next week.
Two weeks time may be given, my lords. 2 weeks.
16th, 2 weeks ಅಲ್ವೇನ್ರಿ? ಇಲ್ವಾ?
After 20, my lords.
After 20 ಕೊಡಿ.
Please, my lords. Any date. Please, my lords.
I am for appellant, my lords. My lords, insurance company appeal, one more appeal is there, 428 of 2021.
Call this a matter along with MFA 4
428 of 2021.
to 8 of 21.
Please, my lords.
Call on, list on.
Serial number 46, my lord,
Yes,
filed by the KSRTC. I represent KSRTC, my lord. on the ground of negligence and quantum, this appeal has been filed. My lord, this honorable court in my lord kindly take my lord DD file MFA 3914 that is put up before your lordship. My lord, rejected my contention with regard to the negligence and quantum, however, allowed only with respect to the interest. That may kindly be looked into. This matter also has to be. My lord, on quantum, my lord, in this appeal, I have challenged that my lord, he is the rider of the two-wheeler, having no driving license. And my lord, no driving license, my lord, helmet was not there, minor, all these grounds are there. Quantum, my lord, yes, the KSRTC bus crossed at the center line. That's what, my lord, in the connected appeal. ಕ್ವಾಂಟಮ್ ಅಲ್ಲಿ ಏನಾದರೂ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡಿದ್ರೆ ಬಟ್ ಅವಾಗ ಅಮೌಂಟ್ ಇದ್ದಿತ್ತು 12,500 ಇತ್ತು 9,000 ತಗೊಂಡಿದ್ದಾರೆ.
ಯಾವುದು 3914 ಇದೆಯಮ್ಮ?
ಹಾ ಅಲ್ಲಿ 3914 ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅದರಲ್ಲಿ ನೆಗ್ಲಿಜೆನ್ಸಿ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ಸುಮ್ಮನೆ. ದಟ್ ಈಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪಿಲಿಯನ್ ರೈಡರ್. ಒಂದು ಪಾಯಿಂಟ್ ಹೇಳಿದ್ದಾರೆ, ಸೆಂಟ್ರಲ್ ಲೈನ್ ನಿಂದ ನಮ್ದು KSRTC ವೆಹಿಕಲ್ ಆ ಕಡೆ ಹೋಗಿತ್ತು ಅಂತ ಹೇಳಿ.
So the claimant was a passenger.
No, he was the rider of the two-wheeler.
Rider
In this
of the-
case, in this case. ಅದರಲ್ಲಿ ಪಿಲಿಯನ್ ರೈಡರ್ ಡಿಸ್ಪೋಸಲ್ ಆಗಿರೋ ಕೇಸಲ್ಲಿ, ಇದರಲ್ಲಿ ರೈಡರ್.
Pillion rider in 3914.
ಹಾ ಹೌದು.
The claimant was a pillion rider.
ಪಿಲಿಯನ್ ರೈಡರ್. ಅದರಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ, ಆ ಸೆಂಟ್ರಲ್ ಲೈನ್ ಇಂದ ಆ ಕಡೆಗೆ ಹೋಗಿತ್ತು ನಮ್ದು KSRTC ಬಸ್ಸು.
Which paragraph?
ಅದು ಮಧ್ಯದಲ್ಲಿ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ, ಒಂದು ನಿಮಿಷ ನನ್ನ ಹತ್ರ. Para number 9. The case of the claimants is that on so and so date, during when they reach near so and so, near Kerehalli, at that time, the driver of the bus bearing number so and so drove the vehicle in a rash and negligent manner and dashed to the vehicle of the deceased. Due to the impact, they fell down and Manjunatha suffered severe injuries and succumbed to the injuries. To prove the case of the claimant, first claimant was examined as herself as PW1. In his evidence, he has stated, I have gone through the next part. I have gone through the spot measure and sketch. As per the said documents, the width of the road is about 23 feet. The spot of the accident is at a distance of 15 feet from the left edge of the road towards right side of the road, leads to Tarikere to Bhadravati. It is very clear that the above documents that the driver of the bus has crossed the middle of the road and came to the extreme right side and hit para 10 minutes.
Yes, I have it. Please read.
Yes, minute. I can't have minute. But in this case, minute, I can only say that minute, he was not having driving license. He is a minor and quantum of compensation, may I request your lordships to kindly look into.
Who's the deceased? Who's the deceased?
Deceased, in that another case is the pillion rider.
Correct. So the rider, who's the rider?
Rider is Manjunatha. It is the case of the claimant that on at about he was proceeding on TVS bike, so and so. as billion rider, which was rated by Manjunath.
So in the present case on hand, he is the pillion rider. Huh?
Yes, madam.
So he has suffered injuries.
He suffered injuries.
So how does it affect here? How does it matter?
But he was minor.
Pillion rider.
Pillion rider raided by one Manjunath, Malad, it is stated. Pillion rider which was raided by one Manjunath.
Audrey, he was the deceased.
Yes.
Now, how does it matter, sir?
Malad, he was in this case. It may not, Malad.
It will not
Quantum,
affect-
quantum.
Other case will not affect this case.
Yes, yes, madam.
Because in the other case, Manjunath, who was the rider, he is
Yes.
deceased.
Yes, madam.
Pillion rider in the present case is Vadivelu.
Yes.
He is not a minor, he is 26-year-old.
26-year-old, madam.
Okay. So how does it affect?
That finding, that finding with regard to the negligence may be mentioned in this case and disposed of. As far as quantum is concerned, Malad, your lordship may kindly see the synopsis, Malad.
No, what is the final outcome of that order in the other matter about?
ಅದರಲ್ಲಿ ಬರೀ ಒಂದು ಇಂಟ್ರೆಸ್ಟ್ ಮಾತ್ರನೇ ರಿಡ್ಯೂಸ್ ಮಾಡಿದ್ದು ಸುಮ್ಮನೆ.
From 7% to 6%.
ಅಷ್ಟೇ ಅಷ್ಟೇ
ಅಷ್ಟೇ ಚೇಂಜ್ ಆಗುತ್ತೆ, ಬೇರೆ ಏನು ಚೇಂಜ್
ಇಲ್ಲ, ಇದ್ರೊಳಗೆ ಇಲ್ಲ, 6% ಕೊಟ್ಟಿದ್ದಾರೆ. ಡಿಫ್ರೆಂಟ್ ಜಜ್ಮೆಂಟ್ಸ್ ಡಿಫ್ರೆಂಟ್ ಜಜ್ಮೆಂಟ್ಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಫ್ರೆಂಟ್ ಜಜ್ಮೆಂಟ್ಸ್.
Correct, sir. Now you have filed appeal.
Yes.
So now you are trying to rely on the other judgment in the death case.
Yes.
By the rider.
With regard to the negligence, Malad, there is no negligence that cannot be applied in this case.
That cannot be applied here.
Yes, Malad. As far as quantum is concerned, Malad, your lordship may kindly see, pain and suffering 60,000 rupees has been awarded.
What is that? You have to tell the injuries and other things, no? Whether
Yes.
you have any dispute on that.
Yes, ma'am.
Why there is no representation?
And I wrote the Malad 2 times or 3 times it was posted.
All right. So now you have to point out anything erroneous committed by the tribunal with regard to computation.
Yes, Malad.
What is the age and what is the
Age is concerned 26 years. Income has been taken at 9,000. Date of accident is 2018. As per chart, Malad, it should be 12,500. If that is taken, Malad, everything will. But Malad, your lordship may kindly see, loss of income during laid-up period for 6 months has been awarded. 54,000.
Correct, but what is the injury?
Injury, Malad, para number 15 of the judgment.
Read it.
Multiple lacerated wound over scalp, multiple fracture over the right leg, multiple lacerated wound over the forehead, fracture of bilateral maxillary sinus. Segmented fracture of tibia and comminuted fracture of fibula. Discharge summary issued by reveals that he was sustained grade 3 open comminuted fracture of both bones of right, as per Malad discharge summary. 15 to 24. On 10 days hospitalized ಆಗಿದ್ದಾರೆ.
60 days inpatient ಇದೆಯಲ್ರಿ.
ಇಲ್ಲ, 14/8/2018
Please read para 18.
Para 18 ಅದು ತಪ್ಪಿದೆ ಸ್ವಾಮಿ. 60 days ಇಲ್ಲ, para number 16. PW2 doctor also deposed the same facts. He further deposed that these injuries are grievous in nature. He was treated as inpatient and he had undergone surgery on 15/8/2018. Date of accident is 14/8. Tibia, and he was discharged on 24/8/2018. 15/8 in the 24 on the 10 days.
All right, what is the disability?
Disability, my lord. Yes, my lord.
%?
Yes, 10%. Parents,
10%, whole body disability is taken at 10% only.
10%, 10%.
So what is wrong in this?
Disability, my lord, percentage of disability may not be wrong. My lord, only thing is, my lord, this 9,000 rupees has been taken as income for 6 months, later period. 54,000 ತಿಂಗಳು ತಗೊಂಡಿದ್ದಾರೆ. Usually 3 months ಕೊಡ್ತಾರೆ. But the loss of amenities ಕೊಟ್ಟಿಲ್ಲ.
No, but that is also good. As per the
Loss of-
chart, it is 12,500.
Yes, loss of amenities ಕೊಟ್ಟಿಲ್ಲ. Pain and suffering, 60,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದ್ರಾಗ
So, Nagaraj, what is
Yes.
taken by the tribunal is on the lower side,
Yes.
even according to you.
Yes, ma'am.
It is taken only 9,000.
Yes,
The chart value is 12,500. They
With
have not
that-
filed any appeal.
it can be disposed of. Amount in deposit may be transferred.
ಇದರಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ 6%
6% ಕೊಟ್ಟಿದ್ದಾರೆ.
ಬರ್ಕೊಳ್ಳಿ. This appeal is preferred by the
Yes, sir.
corporation, challenging the judgment and or passed by the 4th Additional District and Sessions Judge Shimoga sitting at Bhadravati and additional MACT within brackets Roman 4 dated 31st December 2020. It is the case of the claimant that he was a pillion rider along with one Manjunath. And when they were proceeding from Bhadravati to Siddhalipura village on NH 206, BH Road near MC Halli, the driver of KSRTC bus bearing registration number KA11F0483 came in a rash and negligent manner from the opposite direction, dashed against the motorbike, which was ridden by one Manjunath, who died on the spot. Consequently, the claimant, who was a pillion rider, sustained injuries to his face, fracture to both legs, and bodily injury. The claimant was inpatient, undertook treatment, and due to the injuries sustained in the road traffic accident, he filed a claim petition against the insurance company and the driver.
Yes, that is it.
Sorry, the corporation and the driver of the vehicle. Objections were filed by the corporation, taking various grounds. Against the rider of the motorcycle. Upon consideration of the entire matter, the tribunal on the basis of the material evidence recorded, both oral and documentary, awarded compensation of 5,22,776 against the respondent 1 and 2 for the trial before the tribunal, and interest at the rate of 6% per annum. And directed the second respondent corporation to deposit the compensation within 2 months from the date of the order, and imposed other conditions with regard to deposit and release of amount. We'll stop. The corporation has preferred the appeal on the ground that the tribunal has committed an error in passing the judgment, awarded exorbitant compensation, and has not considered the material evidence on record. It is also contended by learned counsel for the corporation that there is negligence on the part of the rider of the motorcycle due to which the accident occurred. Several other contentions are taken by the learned counsel for the corporation with regard to the width of the road and there being no negligence on the part of the driver of the KSRTC bus. And it was the negligence on the part of the rider of the motorcycle who was in the middle of the road and imputes negligence on behalf of the rider of the motorcycle. Be that as it may, full stop. In the present case on hand, the claimant is not the rider, he is a pillion rider. The rider of the motorcycle had suffered injuries and he succumbed to the injuries on the spot, and he had preferred a claim petition which came to be disposed of.
KSRTC preferred.
ಇಲ್ಲ ಹೌದು claimant ಅಲ್ಲಿ ಅವರು deceased.
Yes, yes, madam.
The deceased LRs had preferred claim petition which came to be allowed, and same was questioned by the corporation in MFA 3914 of 2020, which came to be disposed of without interference. No interference.
Except with regard to the interest.
Without interference, except with regard to the reduction of the interest from 7% to 6%. Full stop. Therefore, in the present case on hand, nothing much would survive for the appellant to contend as in the connected matter where the corporation had challenged the claim or the judgment and award of the rider, the LRs of the rider deceased. There was no interference by this court. It would not lie in the it would not lie to the petitioner, the appellant corporation, to take contrary stand. Full stop. The only point for consideration would be whether the tribunal has considered the age, avocation, and income, and whether they are exorbitant in the present case on hand. Full stop. The tribunal, after consideration of the materials placed before the court, has taken the income at 9,000 per month, age of the claimant to be 28 years, and disability to whole body at 10%, and multiplication at 17%, and has arrived at total compensation of 5,22,776, along with interest at 6% per annum. Though several grounds are urged by the learned counsel for the corporation, contending that the income is on the higher side. And the loss of income during later period is calculated at six months, which is exorbitant. I do not find any cogent ground to interfere for the reason that even according to the notional income chart, the income was to be taken at 12,500, whereas the tribunal has taken the income at 9,000. The same would get adjusted towards it under the circumstances. The interest component is taken at 6%, which also does not call for interference. Therefore, I pass the following order. There is no ground to interfere in the present appeal. The appeal is dismissed. The amount deposited by the insurance company shall be transmitted to the jurisdictional tribunal, which shall be dispersed and released in favor of the claimant as per the order of the tribunal. Ordered accordingly.
Please.
Otherly, second para, though their service of notice is held sufficient to the respondent claimant, there is no representation. Then this court is not inclined to accept the petition appeal of the corporation. No further orders required on service of notice to respondent claimant. Gurudev.
I'm ready. It's a case of injuries. He was the appellant was crossing the road, and this KSRTC bus came and dashed against him. The tribunal finding is that the KSRTC bus is negligent to the extent of 90%, and the person who was crossing the road is responsible to the extent of 10%. In para 14 and 15 of the judgment, the only reason given by the learned judge is that he was crossing the road where there was no zebra crossing. Merely because
para 14,
15 and 16. May I read
yes.
I have perused the documents produced by the petitioner. It appears that the care from traffic police have registered the criminal case in crime number so and so against the driver of the KSRTC bus, registered so and so for the offense punishable under section 279 and 337 of IPC on the basis of the complaint lodged by the petitioner. After submitting the FIR, the police have conducting the spot measure and prepared the rough sketch of the accident took place and seized the offending vehicle. After received the IME report and wound certificate, and after completion of the investigation, the IO has submitted the charge sheet against the driver of the offending vehicle for the offense punishable under section.
Dispute
there is no dispute with regard
come to the relevant point. Come to the relevant point.
Yes. In para last in internal page 11.
No, 10. Probably some 10 nalli. You can start from the first line on clearly admitting.
Clearly admitting that after the accident, he was brought the petitioner to the hospital for given the first aid treatment. And after completion of the investigation, the IO has submitted the charge sheet against him, and they have not challenged the complaint and charge sheet. Therefore, mere examine the driver of the offending vehicle is not a ground to denial of the accident and rash and negligent driving. Further, in case if the petitioner is crossing the road with observing the vehicle on the road, definitely the accident could not happen. When the pedestrian crossing over the road at any place other than which is meant for pedestrian crossing, the responsibility for causing the accident more often than not will have to be safe pedestrian along with the vehicle driver. As per the evidence of the petitioner, there is no pedestrian crossing near accident place. Hence, the petitioner is also contributory to the negligence. The respondents have not denied the police documents. If the driver of the offending vehicle is observing the pedestrian on the road and drive the vehicle with cautious and carefully, definitely could be avoid the accident. Further, the petitioner was also not observing the offending vehicle, and if at all, the petitioner could have seen the offending vehicle and allowed it to pass before proceeding to its destiny. The accident could not have occurred. In this regard, I have gone through the judgment reported in ILR so and so. That has been therefore, here in this case also, the petitioner is also responsibility for causing the accident. The petitioner and driver of offending vehicle have not followed the traffic rules and also not drove the vehicle cautiously. Hence, there is some contributory negligence taken on the part of the petitioner to the said accident, but major portion negligence taken on the part of the driver of offending vehicle. Hence, it is considered that the major part of the negligence by the driver of the offending vehicle and the petitioner is also to guilt in the contributory negligence. Accordingly, a portion the negligence on the part of the petitioner is taken at 10% and 90% on the part of the driver of the offending vehicle. My respectful submission is that merely because he was not crossing the road where there was no zebra crossing, the offending driver must take care of the vehicle while driving the vehicle and observe the road. For this 10% contributory negligence has to be set aside. And with regard to the quantum, in para 17, my lord, the petitioner has produced a wound certificate issued by Satyasai Orthopedic and Multi-Speciality Hospital, Bangalore, and 2 discharge summaries issued by the Manipal Hospital, which are marked as Exhibit P8, 10, and 11, respectively. He has also produced the medical bills with support of taking the treatment in the hospital along with his evidence. The counsel of the respondent, nothing has been elicited to deny the injuries submitted by the petitioner in a road traffic accident and also not disputed about wound certificate and also document issued by above said hospital with respect to treatment given to the petitioner. I have perused the wound certificate issued by above said hospital. It discloses that the petitioner taken treatment in the said hospital and the petitioner has sustained injury that is CLW over skull, tenderness plus chest, left shoulder, left AC joint dislocation. The doctor has given opinion that above said injury is grievous in nature. Therefore, taking all these opinion and treatment given by the hospital, it is clearly disclosed that the petitioner has sustained grievous injuries in the road traffic accident. Therefore, taking all these facts and nature of injuries of petitioner, I am of the opinion that the petitioner is entitled for compensation amount of 40,000 as reasonable compensation. Here, he suffered a AC joint dislocation, and he has undergone open reduction and internal fixation with 2 mm fiber tape and 2 dog buttons. 2 occasions he was in the hospital as an inpatient. Therefore, my respectful submission is that the PW2 doctor has given disability of 33% to the limb and 11% to the whole body. Court has taken 10% disability. And he was he was a bank loan agent, earning rupees 15,000. The accident is during the year of 2018. Court has taken only 9,000 rupees income.
2018, huh?
The 2018, 12,500 is the. He was aged about 62 years. 7 multiplier.
That is correct.
Correct. So that has to be increased, loss of future earning capacity. And incidental expenses. 2 occasions he was in the hospital for a total period of 5 days. 3,000 is awarded
Multiplier
for-
correct as 7.
Please, ma'am.
Multiplier 7 is correct.
Multiplier is correct.
So the pain and suffering 40,000 is correct.
I leave it.
Medical expenses actual.
Yes,
Transportation, nourishment, attendant charges.
3,000 is awarded. 5 days and 2 occasions he was in the hospital. That has to be increased.
How much has to be awarded here?
At least 10,000 rupees.
5,000 for 5 days. Because
How many days he was inpatient?
5 days,
5 days.
total 5 days. Because against medical advisement, he was got discharged on the first occasion. Again, next day he got it.
All right. Towards loss of future income, mother.
Yes.
permanent disability.
And future medical expenses.
Future medical expenses, nothing has been stated by the doctor. In spite of it, there is no fracture. Only dislocation.
Dislocation. He undergone surgery.
Anyway, you are not in appeal.
I have not taken.
And amenities,
amenities?
amenities only 10,000 is given.
Because Dr. PW2 is not the treated doctor. He has stated that no fractures, but examined assessed disability within 5 months from the date of discharge and stated 11% whole body disability. In absence of any fracture injury sustained by the claimant, 10% is taken by the tribunal.
Is it reasonable?
That is reasonable.
And loss of income during later period has not been given.
What was he working?
Please, ma'am.
Bank loan agent. And
What he was working as what?
No, bank loan agent. And
Bank loan agent.
Any income you have given?
No, income proof is given.
So that 12,000 has to be taken.
Yes.
In fracture ಏನಾರ ಇದೆಯಾ?
No
Fracture
fracture.
ಇಲ್ಲ, but it is a
Dislocation.
dislocation of AC
AC joint.
joint. Therefore, he undergone surgery with 2 mm fiber tape and 2 dog buttons have been inserted to his.
Fiber tape.
3 months ಕೊಡ್ಬೋದು.
In this case, because in absence of fracture injury,
62-year-old man.
Yes.
Even if he doesn't have a fracture, he can't get up.
2 months can be taken.
All right. So only thing increase will be 5,000 transportation instead of 3,000. And loss of income during later period, 12,500 into 2. That's all. 10% is reasonable. And
Yes, sir.
income to be taken at 12,500.
About negligence aspect, the tribunal relied on sketch the manner of accident. Because the accident took place on the BG road at about during night time at 7 p.m. Your P6 is this sketch which was produced by the before by rely.
10% I'm retaining it. You're not in appeal anyway.
And interest
ಅವ್ರ ಗುರುದೇವ್ ಪ್ರಕಾರ 10% ಹಾಕ್ಬೇಡಿ ನಾವೆಲ್ಲರ ಕ್ರಾಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅವ್ರು.
ಅಲ್ಲಿ interest 9% has been
You
awarded.
have to search when a pedestrian is going to come as a driver.
It is their responsibility.
This appeal is preferred by the claimant who was injured in the road traffic accident on 15/10/2018. Against the judgment and award passed by the MACT and 15th Additional Judge, Court of Small Causes, May Hall Unit, Bengaluru, SCCH 19, dated 3rd June 2019. The brief facts are as under. On 15/10/2018 at 7 p.m., claimant was proceeding on OM Road while crossing the road in front of KR Puram Police Quarters bus stop. At that time, as a pedestrian, at that time, one KSRTC bus bearing number KA07 F1648, driven by its driver, came in a rash and negligent manner. Without noticing the claimant pedestrian, dashed against the claimant, due to which he suffered grievous injuries and was immediately shifted to Satya Sai Hospital, where after obtaining first aid, he was shifted to Manipal Hospital for better treatment. The claimant underwent surgery, spent more than rupees 4 lakhs towards medical expenses, food, nourishment, transport, and other charges. Full stop para. Claimant is aged 62 years, working as a bank loan agent, earning rupees 15,000 per month. Full stop. Due to the injuries suffered and the expenditures incurred, he filed a claim petition seeking compensation against the corporation. Upon appearance of the respondent corporation and objections being filed, evidence was recorded and documents were marked. Claimant got examined 2 witnesses, PW1 and PW2, and got marked exhibits P1 to P14, whereas respondent got marked 1 witness RW1 and 1 document R1. Full stop. The tribunal, upon examining and going through the medical, the evidence, both oral and documentary, awarded total compensation of rupees 3 lakh 27,187.
Less 10%.
And imposed contributory negligence against the claimant pedestrian. And total amount was 2,94,500 with interest at 9% per annum. And directed the respondent corporation to pay the compensation within 60 days from the date of the order. Full stop para. Being aggrieved by the meager compensation, claimant is before this court in appeal. It is a contention of learned counsel for the claimant that the judgment and award passed by the tribunal is on the lower side. The contributory negligence fastened on the claimant is erroneous, as it should have been the duty and obligation of the driver of the KSRTC bus to have taken care while driving the bus, even if a pedestrian is crossed in the area which is not earmarked for a pedestrian crossing. And if the driver was careful, the accident could have been avoided. Full stop. It is also the vehement contention of learned counsel for the claimant that the tribunal has taken the income on the lower side. The tribunal ought to have taken the income at 12,500 per month rather than rupees 9,000, which is again on the lower side. He further contends that the tribunal is not awarded compensation under the head loss of income during later period, and towards food, nourishment, and attendant charges also, the compensation awarded is on the lower side. On these grounds, he seeks to allow the appeal and enhance the compensation. Full stop. Per contra, learned counsel Shri So-and-so, appearing on behalf of the respondent corporation, sustains the order of the tribunal on the contrary, contends that the contributory negligence ought to have been fastened more than 25%, as it is at the fault of the pedestrian. The accident has occurred, and that too in a place which was not earmarked for pedestrian crossing. There is no material placed on record with regard to income of the claimant. The income adopted at 9,000 is correct and does not call for interference. So also, the compensation awarded under other head does not call for interference. Full stop. Having perused the impugned order and having heard learned counsel for the appellant and the respondent, the point that arises for consideration is whether the appellant claimant is entitled to enhancement of compensation. The answer to the above, in my opinion, is partly in the affirmative for the reasons herein below stated. The occurrence of the accident, involvement of the vehicle and the claimant as a pedestrian is not in dispute. Age of the claimant to be 62 years is not in dispute. Multiplier adopted by the tribunal at 7 is correct and does not call for interference. The income of the claimant taken at 9,000 is on the lower side, same requires to be taken at 12,500 as per the notional income chart. Accordingly, income is taken at 12,500. The contributory negligence awarded by the tribunal is on the is correct, as it is apparently seen that the place where the claimant has crossed the road is not designated for a pedestrian crossing. And the pedestrian or claimant cannot expect the driver to suddenly notice a pedestrian coming from nowhere in the middle of the road when traveling in such high speed. Therefore, I am not inclined to interfere with the contributory negligence fastened against the claimant at 10%. Same is retained. Full stop. Towards pain and suffering, tribunal has awarded 40,000, same is retained. Towards medical expenses, 1,78,587 is retained on actual expenses incurred. Towards loss of future towards medical expenses, 20,000 is retained. Towards loss of amenities, tribunal is awarded 10,000, same is enhanced to 25,000. Full stop para. Tribunal has not awarded loss of income during later period, taking the income at 12,500 per month for a period of 2 months. 25,000 is awarded under this head. Full stop. Towards
conveyance
of future income due to disability is still there.
10% has been taken.
33% to the limb and 11% to the whole body.
Disability is taken at 10% by the doctor who's examined as PW2. Same is retained as no cogent material is produced to disbelieve the doctor, though learned counsel for the corporation contends that he is not the treating doctor. Nothing prevented the corporation from examining or producing anything material which contrary to what PW2 has produced. Hence, the disability at 10% is retained. Under the circumstances, 12,500 into 12 into 7,
7.
into 10%. Next item.
1 lakh.
1,05,000 is awarded under this head instead of as against 75,600. 1,05,000 is it?
1,05,000.
Yes, as against 75,600. Under the circumstances, I pass the following order. Claimant would be entitled to total compensation of 3 lakhs 587 minus 10% towards contributory negligence. Which would be 2 lakhs 3,56,928 with interest at 9% per annum.
6%.
Same is retained. You have paid amount or not yet paid?
We have
Satisfied?
satisfied.
The future, the enhanced income, the enhanced compensation shall carry interest at 6%.
6%. And there was delay of not 172 days.
Future medical expenses.
And there was delay of 172 days, murder.
172 days.
Payment shall not be entitled to interest for the delayed period of
172 days.
172 days.
172.
Yes.
172. Ordered according. The amount shall be dispersed, released in favor of the claimant upon proper verification and identification.
Serial number 48, my lord. Big time may be granted, my lord. Serial number 48.
You are for?
I'm for the respondent number 2, my lord. Appellant advocate.
At request of both parties, call this matter on.
Serial number 62, my lord.
Serial number 73, my lord.
Yes, sir.
I am for R2. I've informed the other side anytime during next week.
All right, at request of learned counsel for respondent number 2, call on 2 weeks.
Serial number
My
60,
lords, kindly,
61,
my
Lord.
85, my
61.
61.
Madam,
There are two appeals made, one by the corporation and another by the claimant.
Connected appeal, I appeal for appellant. my lord.
He has served the copy made today.
I have served the copy, my lord.
Next week, murder.
At request of both counsels, released on.
My lord, serial number 90.
with my lords kindly.
Adjourn ಆಗಿದೆಯಲ್ಲ 81 ಅಲ್ಲ? It's adjourned, madam.
Serial number 62, my lord.
21st ಕೊಟ್ಟಿದ್ದಾರೆ date.
My lord,
62, my lord.
Serial number 85, my
My name is wrongly shown in the caste title of ಇದ್ರಲ್ಲಿ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮೇಡಮ್ ಸತೀಶ್ ಟಿ ಏನೋ ಸತೀಶ್ ಅಂತ ಇದೆ ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಬರ್ತಾ ಇಲ್ಲ kindly correct. 62 ಸತೀಶ್ ಟಿ ಮೇಡಮ್
ಸತೀಶ್
ಎಸ್ ಮೇಡಮ್
registry to correct the name of learned counsel for respondent number 3 as Satisha SHA instead of Satish T in the cost list.
My lord, serial number 90.
Next week, madam.
For R,
Call this matter in next week.
92 serial number for R2. Kindly 1 week time may be granted.
92
92 for Chala.
at request of R2. Call after 2 weeks.
Much.
lord.
My lord, serial number 86, my lord.
85, my lord. Kindly weeks of time granted, my lord.
85 at request of learned counsel for the appellant, call on.
86 also, my lord.
86 at request of learned counsel for appellant, call on.
2 weeks friends, my lord.
2 weeks.
More than yes.
23rd.
27th onwards, man. There is some,
27th you want, is it?
and that after that any date. ma'am.
All right, 28.
Obligation.
'75 at request of learned counsel for both parties, call on. When do you want? Next.
After 2 weeks.
After 2 weeks.
Serial number 90.
94. 94. All right. Request of learned counsel for appellant colon. 23rd.
Serial number 90, my lordship.
Hmm.
I am for respondent number 2, behalf of N. Krishnasamy, I am representing my lordship. Some inconvenience senior, my lordship. Maybe any,
Of respondent number 2 colon.
any date, my lord, next week.
Serial number 57, my lord.
Please, my lord.
I'm the petition appellant in this case, my lord. And I've done any after the second week, my lord.
At request of appellant
Yes, ma'am.
colon.
57.
57.
Any.
Only on quantum? Ah. Hmm. Hmm. So chart value. No income proof.
No.
So 2019 is to 14, huh? Illi madam, chart alla kodbekalla. No, the roster. Keep it separately, you know, the roster when we having MBC, EC, ಎಲ್ಲ ತಗೊಂಡು clean ಆಗಿ more ಇಟ್ಕೋಬೇಕು. Hmm. Two 2019, 14,000 ಅಲ್ಲ? Hmm. Hmm. %17%. Now, what is the income taken? Hmm?
10,000. Para 13, para 13.
30,000. 10,000 ತಗೊಂಡಿದ್ದಾರಲ್ಲ.
As a future income was not granted on the ground that he was doing a business.
Business.
Apart from that, the quotas consider that, but only thing is, he was doing a business.
No, now let him finish. What the tribunal has taken assessment of 10,000 per month. Not awarded. So 10,000 and what is up? So it should be 14. Hmm. 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 ಅದು ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಹ್ಮ್. ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಮ್ಮ? ನೋಡಿ.
para 20 of the judgment.
11. ಏನಾಗಿದೆ? What is it? Huh? Both bones. Ankle bone. Any reduction? No reduction.
No, ma'am. As
No.
per the evidence.
No reduction in the size
No.
of the leg. All right. Ankle bone fracture. In 17% disability ಏನಿದೆ ಅದರಲ್ಲಿ?
It's on the area.
49% left lower limb. ಏನಿದೆ 49%? ಅವನು in sports person 49%.
The tibia fibula fracture can amend 100% coverage on it. But it is, in this case, madam, we assess the on the higher side. Therefore, court has come to conclusion he is not the treated doctor and he is continuing doing the same business.
No, whether he's treated doctor or not treated doctor, that may be immaterial. The question is, 49% left lower limb means if it is affecting whether he's a driver, he's doing some agriculture work with his leg, that has to be taken into consideration for awarding compensation. Maybe 49%, but depends upon the avocation. On cycle ತುಳಿದು ಏನಾರ ಕೆಲಸ ಮಾಡಿದ್ರೆ, it may be affecting. But he is a businessman sitting in a shop. Maybe for movement it may be difficult from one place to the other. But you are not in appeal.
We are not.
So you are not challenging that.
No, court has not granted any comment.
17% ಮಾಡಿಲ್ವಾ?
That court has not granted the compensation, still he is continuing doing the same business. There is no loss of ability.
That is the finding of the tribunal.
Facing exhibit, the para 20 of the judgment may kindly be seen.
ನಿಮ್ದಾಯ್ತಾ ಅಷ್ಟೇನಾ? Yes.
Para 20. ನಾನು ಸಿಬಿಐ ಕೊಟ್ಟು ಬೋಗಿಗೆ ಪಡೆದಿರ್ತೇನೆ. So and so ಫೆಬ್ರವರಿ ಜಮೀನನ್ನು ವಶಕ್ಕೆ ಪಡೆದುಕೊಂಡಿದ್ದೆ. So and so ನನ್ನ ಮನೆ ಹೆಸರಲ್ಲಿ ನೋಡಿಕೊಳ್ಳುತ್ತಾರೆ. ಸಿಬಿಐ ಕೊಯ್ಲು ಮಾರಾಟ.
ನೀವು ನಿಧಾನ ಕನ್ನಡ ಓದಬೇಕು. ನನಗೆ I am relying on your Kannada, not my reading Kannada.
Please. No, the sons of this Melan, he has admitted that he is doing the earlier what he was doing, the very same
Business. What is this business?
CBI Marat.
He's a fruit vendor, vegetable fruit vendor. In the shop or in the cart?
No, it is not disclosed.
Disclosed.
Evidence, but he is.
Where are you doing the business?
Petty business.
ಇಲ್ರಿ ಅಂಗಡಿಯಲ್ಲಿ ಕೂತ್ಕೊಂಡು if there's a rental shop. But you are not street vendor ಅಲ್ಲಲ್ಲ? ಇನ್ನೇನ್ ಮತ್ತೆ? ಹೋಗಿ ತಕೊಂಡು ಜಮೀನನ್ನ. All right. Yes.
The land was looking after their family members according to the admission given by the PW. Therefore, on considering the evidence of the document, the court has not granted any compensation under the future loss. Therefore, under the head of paying suffering, some amount is required to be payable.
No, the business, what he's saying, he's not sitting and somebody else is coming and giving. He says he has to go and fetch it. Then the movement is involved, Allah.
But thing is, my lord, the land was looking after by their family members. So there is no loss in that. Only for his convenience to go to market or something like that, there is some. Therefore, the disability assessed by the doctor is on the higher side. Considering the trend of this court, High Court, 12% disability be taken into consideration. considering the present note and
Question of reducing 12%, you're not in appeal.
court has not granted any compensation.
So on a
If it is
middle
granted,
path, you
I
are
would
saying,
have-
all right, okay,
If it is granted, I would have, but
All right.
therefore, I am,
all right.
and the rate of interest is granted 9%.
That also you are not in appeal.
No, but that is the reason that overall, considering the overall compensation, the compensation granted by the court will system is. If it is,
Going to be
Yeah.
enhanced.
then I'm seeking your lordship intervention regarding that.
All right. That's all.
That's all.
Very good. This appeal is preferred by the claimant, challenging the judgment and award of the tribunal dated 5th August 2021 in MVC 2599 of 2019. Brief facts are: the petitioner was riding his motorcycle bearing registration number KA01EN4496 on BB Road NH7 on 30th March 2019, slowly and cautiously by observing traffic rules and regulations. Full stop. When the claimant reached the Hosur flyover, a car bearing number KA50M0934, driven in a rash and negligent manner, came in high speed and dashed against his motorcycle. Full stop. The claimant fell down, sustained grievous injuries, and he was admitted to Ashwini Hospital, where he secured first aid treatment and thereafter shifted to Hosmat Hospital, where he was treated as an inpatient and incurred nearly 5 lakh rupees towards medical, nourishment, travel, and other miscellaneous expenditures. Full stop. In view of the injuries suffered in the accident, the claimant filed a claim petition seeking compensation against the respondent. The respondent insurance company and the owner of the car, offending vehicle, filed statement of objections, denied the averments made by the claimant. By taking a plea that the accident was occurred due to the negligence of the claimant himself. And sought for dismissal of the claim petition. Claimant examined himself as PW1 and the doctor as PW2, got marked exhibits P1 to P24. Whereas the respondents did not lead in any evidence or produce any documents on their behalf. Full stop para. On the basis of the documents produced, both oral and documentary, on the basis of evidence produced, both oral and documentary, the tribunal awarded total compensation of rupees 4 lakhs with interest at 9% and ordered the respondent 1 and 2 to jointly and severally pay the compensation within 1 month from the date of the order. Full stop para. Being aggrieved by the inadequate compensation awarded by the tribunal, the claimant is before this court seeking enhancement. It is the vehement contention para of the learned counsel for appellant claimant that the judgment and award passed by the tribunal is arbitrary, illegal, and contrary to the material evidence placed on record. It is further contended that tribunal has not awarded compensation towards loss of income due to disability, loss of future income due to disability, except for awarding rupees 40,000 as global compensation. Towards even amenities of life, loss of amenities of life, a meager compensation is awarded. The tribunal has failed to take into consideration the injuries suffered and the disability to an extent of 17% to the whole body, 49% to the left lower limb, and has failed to take into consideration the difficulty, the disadvantage, and the loss of earning capacity due to the injuries suffered in the accident. On these grounds, learned counsel for the claimant contends that the compensation awarded is on the lower side and the same requires to be enhanced. Full stop para. Per contra, learned counsel for the insurance company vehemently contends that the judgment and award does not call for interference as a reasonable compensation is awarded, taking into consideration the magnitude of injuries, the evocation of the claimant, and also the disability that may interfere with the future earning capacity. It is also contended by learned counsel for the insurance company that on other grounds, the tribunal has awarded reasonable compensation. In fact, the interest component awarded is on the higher side. And in case this court were to increase any compensation on any of the heads, the interest component be reduced to 6% rather than 9%. On these grounds, he seeks dismissal of this appeal. We'll stop. Having heard learned counsel for the appellant claimant and the respondent insurance company, the point that arises for consideration is whether appellant claimant is entitled to enhancement of compensation. The answer to the above question is partly in the affirmative for the reasons stated here and below. It is not disputed with regard to occurrence of the accident, involvement of the vehicle, injuries suffered by the claimant due to the accident. Therefore, the negligence is rightly attributed to the driver of the offending vehicle. Stop. Para. Now, coming to the aspect of quantum of compensation regard to age, avocation, income, and the appropriate multiplier to be adopted. It is seen that the claimant is aged 47 years as on date of occurrence of accident. And he was running a business. Though he has stated that he's earning 30,000 per month. Nothing cogent is produced to show the amount of income that he was generated by the claimant. Considering the nature of work of the claimant, Tribunal has come to a conclusion that 10,000 could be the monthly income of the claimant. However, no amount is awarded towards loss of future earning capacity. Be that as it may, this will be dealt with in the due course. Full stop. The notional income chart for the accident of the year 2019 describes 14,000 per month as the income. Same can be taken as income of the claimant in the present case. Full stop, para. Claimant has got examined the doctor as PW2. Who has opined that there is a disability of 49% to the left lower limb and 17% disability to the whole body. Though PW2 is not a treated doctor, he is an orthopedic surgeon at Hosmet Hospital. He has provided his expert medical opinion with regard to the disability suffered by the claimant. Nothing contrary has been established in the cross-examination by the respondent insurance company. The disability can be taken to an extent of 12% to the whole body. In the present case on hand, considering the avocation and age of the claimant. It is not possible that a person having suffered disability to an extent of 49% to the left lower limb or 17% as assessed by the tribunal would not have any economic or functional disability in performing his day-to-day business activities. Be it an avocation of just sitting in one place and doing business. Under the circumstances, though nothing much is elicited in the evidence of the claimant, this court is of the opinion that 12% could be taken as disability for calculating the loss of future earning capacity of the claimant. What is the multiplier? $13. In view of the fact that the claimant is aged 47 years, the appropriate multiplier would be 13, which should be applicable in the present case on hand. Therefore, taking the income at rupees 14,000 per month and applying the multiplier as 13 and disability at 12%, the loss of future earning capacity would be 14,000 into 12 into 13 into 12%. 2,62,080 rupees. This should be as against the disability awarded at 40,000 by the tribunal. We'll stop para. Towards medical expenses, tribunal is awarded 2,85,000, same is retained as it is on the actual expenditures incurred by the claimant. Towards attendant charges, food, nutrition and conveyance, 5,000 is awarded, same is retained. Towards pain and suffering, 20,000 is awarded by the tribunal, another 10,000 is awarded under this head. Towards loss of income during later period, tribunal has not awarded any amount. Considering the income at 14,000 per month into 3 months for recuperation. Just take the amount. 42,000 is awarded under this one, under this head. Towards loss of future amenities and happiness, tribunal is awarded 25,000. An additional 10,000 could be awarded under this head, considering the injury suffered by the claimant. Towards future medical expenses, 25,000 is awarded, same is retained. Is anything else? Full stop para. Learned counsel for the respondent corporate insurance company contends that in view of this court enhancing the compensation under the head loss of future income, the interest component could be reduced to 6%. Though the insurance company is not in appeal, in view of this court enhancing the compensation and awarding loss of future income due to disability, this court deems it appropriate to reduce the interest component to 6%.
Enhanced. For enhanced.
And for 6% towards the enhanced compensation. Stop. Full stop. Accordingly, I pass the following order. Madam, claimant would be entitled to total compensation of 6,84,080 rupees, along with interest at 9% per annum. Accordingly, I pass the following. Appeal is allowed in part. The judgment and award passed by so-and-so is modified. Compensation is enhanced to 6,84,080 rupees as against 4 lakhs. Along with interest at 9% per annum. Stop. For enhanced compensation, interest shall be calculated at 6% per annum. The compensation shall be paid by the respondent 1 and 2 within 4 weeks from the date of receipt of copy of the order. Any amount paid,
They have already deposited the tribunal.
only balance compensation has to be
And it will be added.
balance compensation. Fracture of both legs. ಎಷ್ಟು 9,000. What was he? Priest. Hmm. Hmm. When is the accident? 2018. Oh. It's 12,500. Hmm. 54% ಅಂತ ಇದೆಯಲ್ಲ. That is taken. Taken but not awarded, is it?
Paragraph number 17.
ಇದೆಯಲ್ಲ.
9,000 ತಗೊಂಡು 11 multiplier apply ಮಾಡಿ 9% ತಗೊಂಡು.
See, income is taken at 9,000 multiplied by 11. 9% is the disability that is assessed. So they have taken disability. No, you said nothing is taken. You have to say it is a reduced amount that is taken. Padima. What is the age? 45 or 55?
55.
Multiplier ಎಷ್ಟಾಗುತ್ತೆ? 11. 11.
ಇನ್ಕಮ್ ಜಾಸ್ತಿ ಆಗಬೇಕು, ಡಿಸಬಿಲಿಟಿ ಜಾಸ್ತಿ.
11 is correct. Disability ಎಷ್ಟಾಗಬೇಕು? 27%.
54% to be removed. 1/3 has to be taken into consideration, only 18%. Even 20% consider because of the photograph. Full fracture.
My God. ಎಲ್ಲ ಬಂದ್ಬಿಟ್ಟಿದೆಯಲ್ರಿ ಅವ್ರ ಮೂಳ ಕಾಳು ಎಲ್ಲ ಅವ್ರು ಸ್ಟಿಚ್ ಮಾಡ್ಬೇಕು ಅದು. ಡಾಕ್ಟರ್ ಕೆಲಸ ಇಸ್ ನಾಟ್ ಸೊ.
ಬೇಕಾಗಿರಲಿಲ್ಲ ನೋಡ್ಬಿಟ್ಟೆ ಬೇಕಾದ್ರೆ ಟ್ರಿಬ್ಯುನಲ್ ಕೊಡ್ಬೋದಾಗಿತ್ತು.
ಟೆರಿಬಲ್ ಥಿಂಗ್. So what was this man doing? What was his avocation? What was his avocation? Priest.
He cannot do it. ನಿಂತ್ಕೊಂಡಿನ ಕೆಲಸ ಮಾಡಕ್ಕಾಗಲ್ಲ, ನೋವು ಬಂದೇ ಬರುತ್ತೆ. There is a gate also. There is.
So he is agreeing with you. He is not differing, he is agreeing. The question is, what is the 54%, whole body, I mean, particular limb?
54 to the lower limbs.
ಅದೇ
ಅಂತ ತಗೊಂಡ್ರೆ 18 ಬರುತ್ತೆ. Even 20% ತಗೊಳ್ಳಿ ಸರ್.
Yes.
Income ಜಾಸ್ತಿ ಆಗ್ತದೆ.
Why? Anything was disputed, Mr.
Paragraph number 18.
No, merely because advocate does not object doesn't mean that the judge cannot take it.
Paragraph number 18, sorry.
All right, we'll see that. What else? That's all. No, one is you're on medical expenses, the future income. What about towards pain and suffering? ನೀವ್ ಹೇಳ್ಬೇಕಲ್ಲ ಮತ್ತೆ. ಎಷ್ಟು ಕೊಡ್ಬೇಕು? ಸಾಕ? ನಾವೇ ಜಾಸ್ತಿ ಕೊಡ್ತಿದ್ವಲ್ರಿ. Have you seen? You only told me the photographs and how much amount of pain, whether this amount of 30,000 can. If you sit in a four-walled hospital and look at the photographs, it's terrible. All right. ಅವರೇ ಹೇಳ್ತಾರೆ ಒಂದು ರೀಸನಬಲ್ ಅಮೌಂಟ್.
ಇದೊಂದು 50,000 ರೂಪಾಯಿ ಪೇರೆಂಟ್ ಸಫರಿಂಗ್ ಜಾಸ್ತಿ ಆಗ್ಬೇಕು. ಫ್ಯೂಚರ್ ಇನ್ಕಮ್ ಅಲ್ಲಿ ಜಾಸ್ತಿ ಆಗ್ಬೇಕು. ಅಟೆಂಡೆಂಟ್ ಚಾರ್ಜಸ್.
ಎಷ್ಟು ದಿನ ಇನ್ಪೇಷಂಟ್? How many days inpatient? Inpatient.
Loss of income during later period ಕೊಟ್ಟಿಲ್ಲ. Amenities ಅದೇ ಕೊಟ್ಟಿದ್ದಾರೆ. 35 shares.
This happened in which place? Bangalore or somewhere else? Vijayapur. ಎಲ್ಲಿ ಬರುತ್ತೆ ಅದು? ಚಿಕ್ಕಮಗಳೂರು.
Was filed before MSCT Bangalore.
No, for awarding this attendant charges, food, nourishment and other things. Locality differs. Cost of living in Bangalore is high. In other places, it may be little lower.
Mangalore, Shimoga.
4 months.
ಅದು AJ ಹಾಸ್ಪಿಟಲ್ 25 ದಿನ ಇದ್ರು.
ಅದಾದ್ಮೇಲೆ
AJ ಹಾಸ್ಪಿಟಲ್ ಮಂಗಳೂರಲ್ಲಿ 25 ದಿನ ಇದ್ರು. ಮತ್ತೆ ಶಿವಮೊಗ್ಗಕ್ಕೆ ಬಂದ್ರು. ಅಲ್ಲಿ ಕೆಲವು ದಿನ ಇದ್ರು.
So 4 months you are not disputing.
ಅದು ಕೊಳ್ಳಿಲ್ಲ.
4 months ಅಂದ್ರೆ 120 days.
6 months. Loss of income during later period. He was treated as inpatient almost 4 months.
No, only for this attendant charges, food, nourishment, conveyance. That one we will calculate what is inpatient days. The loss of income later period, that is separate. So if 4 months inpatient andre, 4 3 is 12, 120 days he was inpatient. So even if you calculate at 500 rupees per day, 60,000 has come.
2,500 is granted.
So that will become 60. Then apart from that, loss of income during later period is not given. Plus 6 months, 4 plus 6. Plus 4 months, nothing he gets. So 10 months. One lakh 25.
1,25,000. Amenities.
Amenities ಎಷ್ಟು ಕೊಡ್ಬೋದು?
ಇದೊಂದು 35,000.
Pain and suffering 50.
10 ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದೊಂದು 50,000 ಜಾಸ್ತಿ.
Yes. Loss of future income 12,500 into 12 into 11 into 20%. ಎಷ್ಟಾಯ್ತಮ್ಮ? 3 lakhs.
Minus 1,06,090.
Yes. That's all.
Subsequent to disposal of the claim petition.
Huh?
Subsequent to disposal of the claim petition, he has incurred some expenses and those bills are enclosed along with the application. Additional documents.
ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ. Now, what about the medical expenses which he says about 5 lakhs and all?
Paragraph number 18. So.
ಓದಿ ಅದು ಸ್ವಲ್ಪ. Why it is not considered? Please read.
The petitioner has produced hospital and medicine expense bills as per exhibit P14, 226 in numbers. Hence, an amount of rupees 2,63,602 is awarded towards medical charges. The petitioner has produced ambulance receipts as per exhibit P11, but the petitioner has not produced any supported evidence to show that on the dates mentioned in the ambulance receipts, he went to the hospital and took treatment. Hence, the ambulance bills are not considered. The petitioner has sustained a fracture of tibia and fibula of right leg. The said injuries clearly goes to show that the petitioner has suffered some pain and hence an amount of 10,000 is awarded to the petitioner under the head pain and suffering. Further, the petitioner was admitted to AJ Hospital and Medical Science. As per AJ Hospital bill, the petitioner was admitted to the head hospital on 28/12/2018 and discharged on 21/10/2019. By perusing the same, it appears the petitioner was admitted in the head hospital for 25 days. Hence, an amount of rupees 2,500 is granted toward attendance charges. An amount of 15,000 is awarded towards loss of amenity. The petitioner is entitled for compensation of the following.
Not much of discussion. ಅದೇನು ಅದು 25 days ಅಂತ ಹೆಂಗ್ ಬರುತ್ತೆ? Almost 10 months he is admitted. 2018 to 2019.
Discharge ಸಮಯ ಇಲ್ಲ, 4 months. 28/12/2018
See, you are saying you are admitted on 12 December 2018, discharged on October 2019. Do you have the discharge summary? Yeah. But then why you said 4 months inpatient?
Three discharge summaries are there. Exhibit P8.
All right, totally together if you calculate, whether it comes to 10 months or only 4 months? 10 months. 4 months ಅಂತಾರಲ್ರಿ. ಕಡಿಮೆ ಬೇಕಂತಲ್ಲ ಅವ್ರಿಗೆ.
ಇಲ್ಲ ಪಾಪ ಅವ್ರಿಗೆ ತೊಂದರೆ ಮಾಡೋದು ಬೇಡ, ಪಾಪ ಕಮ್ಮಿ ಮಾಡೋದು.
ಏನ್ ಕಾಂತರಾಜ್ ಅವ್ರು, ಶಾಂತರಾಜ್ ಅವ್ರೆ, ಕಡಿಮೆ ಕೇಳ್ತಾರಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ ಜಡ್ಜ್ ಸಾಹೇಬ್ರು? ಅವು
1,25,000.
ಇವಾಗ ಎಲ್ಲ ಕೇಸಲ್ಲಿ ಕೋರ್ಟೇ ಜುಡಿಷಿಯಲ್ ನೋಟಿಸ್ ಹಾಕಬೇಕಂದ್ರೆ ವಕೀಲರು ಏನ್ ಮಾಡೋದು ನೀವು? ನನಗೆ ಇದೇ ಸಮಸ್ಯೆ ಬಂದಿದ್ದು ಧಾರವಾಡಲ್ಲಿ. ಅಡ್ವೊಕೇಟ್ಸ್ ಪೆಟಿಷನರ್ ಅಂಡ್ ರೆಸ್ಪಾಂಡ್ ಕೇಳಿ ಜಜ್ಮೆಂಟ್ ಬರೆದ್ರು ನಾವು. ನೀವು ರಿಲೈ ಮಾಡೋ ಜಜ್ಮೆಂಟೇ ಓವರ್ ರೂಲ್ ಆಗಿರೋ ಜಜ್ಮೆಂಟ್. ಫುಲ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಒಂದು ಕೊಟ್ಟಿದ್ರು ನನ್ಗೆ. ಫುಲ್ ಬೆಂಚ್. By chance, I had to look into by afternoon lunchtime. Overruled by the Supreme Court. Radre, the standard of advocacy goes down. You have to come fully prepared. He is agreeing to it. Suppose somebody else were to be there, they may object to it and you will get lesser compensation because of your not preparing the case. No, not sorry. I'm not demoralizing you. What I'm trying to tell you is that you should come prepared. Not ivaga, whether it is 10 months, I will grant you 10 months. Yes, discharge. When he is admitted, when he is discharged, just do some calculation.
The more hospital is there. 10 months.
10 months. ಅದೇ ಆಯ್ತು. 10 months ನಿಮಗೆ ಬರೀ inpatient ಬರುತ್ತೆ. Apart from that, 6 months because you cannot go in for any work because of the amount of surgery and the magnitude of the accident. So that will become not 4 months, and you'll have to add 4 months with the 10 months, 10 into. ನಿಮಗೆ ಬಿಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅವ್ರು ಅಪೋಸ್ ಮಾಡ್ತಾರೆ ಶಾಂತರಾಜ್ ಅಸಿಸ್ಟೆಡ್ ಅಂತ. Thank you for your assistance. I will appoint you as amicus curiae in some other matter. ನಮ್ಮ ಸೀನಿಯರ್ ಹೇಳ್ತಿದ್ರು ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಇರುವಾಗ, ಯು ಡೋಂಟ್ ಲಾಯ್ಟರ್ ಅರೌಂಡ್ ಇನ್ ದಿ ಕಾರಿಡಾರ್, ಸಿಟ್ ಇನ್ ದ ಕೋರ್ಟ್ ಅಂತ. ಇವಾಗ ನಮಗೆ ಅದು ಬರ್ತಾ ಇದೆ, ವೈ ವಿ ಶುಡ್ ಸಿಟ್ ಇನ್ ದ ಕೋರ್ಟ್. So sometimes when you hear the arguments of senior counsel like Mr. Shantaraj or N. Krishnamurthy or my brother who's practicing on the insurance side, you will gain. So whenever any such matter comes, you have to sit in that particular court for at least half an hour, understand the mind of the judge, whether he is giving less or more, and then start arguing. ಅದೇ 300 days ಆಗುತ್ತೆ.
125 become another 125. 250,000.
1,20,000. ಇಲ್ಲ, ಅದು ನೀವು 10 months ಮಾಡಿದ್ದು ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಆಯ್ತು.
4 months ಅಂತಂದಾಗ 10 months ತಗೊಂಡಿರ್ತಾವೆ.
ಇಲ್ಲ, the 10 months of loss of income during laid up period. The food, nutrition, attendant charges and conveyance. I don't know that now that will become this 10 months. So 10 months will be 300 days.
1.5 lakh.
Huh?
1.5 lakh.
So instead of 60,000, madam, it is 1,50,000. That's all, sir. Medical then ಮಾಡೋದು ಮಿಸ್ಟರ್
Ambulance bills ಇದು ರೀಸನಿಂಗ್ ಸರಿ ಇಲ್ಲ ಅಂತ ತಾವೇ ಒಪ್ಕೊಳ್ಳಿ.
Now why it is reduced from 5 lakhs to 2,63,000?
ಇದು ambulance bills ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಅದಿದೆಯಾ? ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ಇಸ್ ಆಂಬ್ಯುಲೆನ್ಸ್ ಬಿಲ್.
18 ನಲ್ಲಿ Petitioner has produced ambulance receipts as per exhibit P11.
He has not produced any supported evidence to show that as on the date mentioned ambulance, he went to the hospital. How can that be? He has gone to the hospital, he has taken treatment.
Ambulance ಅವರು ಕೊಟ್ಟರು ಬಿಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
So if that is added, it becomes.
ಹೋಗಿದ್ದಾರೆ ಹಾಸ್ಪಿಟಲ್ಗೆ, ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
ಇದು 70,000 ಇದೆ. So this is 70,000 bills. What about how you came at 5 lakh rupees? All right. 263 ಕೊಟ್ಟಿದ್ದಾರೆ. So even if we add that 70,000, it does not reach 5 lakhs. Where is your consolidated bill? Consolidated bill idea? Medical. Which is that exhibit? ಇಲ್ವಾ? ನೀವು ಕೊಟ್ಟಿರಲ್ಲ, ಇಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು. ಇಷ್ಟೆಲ್ಲ ತಗೊಂಡೋಗಿ ಕೊಟ್ಬಿಡ್ತೀರ ಅವರು, ಎಲ್ಲಿ ಹುಡ್ಕೋದು ಅವರು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್? Where is that?
Ambulance bills ಅವರು 5 in numbers ಮಾತ್ರನೇ ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬೇಕಾದ್ರೆ.
There is a calculation here. Total bills 1,68,000. Total hospital bids paid at Shimoga 1,42,000. Total bills paid at AG Hospital Mangaluru 1,49,000. Ambulance bill 70,000. Total 5,30,695. That can be deducted. ತೋರ್ಸೋ ಅವ್ರಿಗೆ.
ನೋಡ್ರಿ ಕರೆಕ್ಟ್.
$4,60,000. ಬರ್ಕೊಳ್ಳಿ. ಯಾವ್ದ್ರಲ್ಲಿ? ಆಂಬುಲೆನ್ಸ್ ಅಲ್ಲ,
ಬಿಲ್ 5 in numbers ಅಂತ ಹೇಳ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಇದೆ 5 ಬಿಲ್ಸ್ ಇದೆಯಲ್ಲ,
ಅಷ್ಟೇ ಇದೆ. ಅಷ್ಟಕ್ಕೆ 70,000 rupees ಬರೋದು.
ಆಲ್ ರೈಟ್, ಬರ್ಕೊಳ್ಳಿ.
ಆಮೇಲೆ ಸ್ವಾಮಿ ಅಡಿಷನಲ್ ಬಿಲ್ಸ್ ತಮ್ಮ ಮುಂದೆ ಕೊಟ್ಟಿರೋದು 20,150. 20,454 ಬರುತ್ತೆ, ಅದಕ್ಕೂ ಕೊಡ್ಬೇಕು.
ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. What is the additional after that here? So total ಮಾಡಿದ್ದೀರಾ? 4,218 ಇದೆಯಲ್ಲ ಅದ?
16,236, 4,218.
$16,236 plus 4,000.
ಹೌದು,
218.
20,454.
20,000?
454. 20,454.
450. This appeal is preferred by the claimant. Questioning the judgment and award passed by in 13th ASCJ, small causes additional MACT Bengaluru in MVC 2512 of 19, dated 29 July 2021. Party shall be referred to as per the status before the tribunal. Brief facts of the case. On 8/12/2018, at about 7:30 PM, the petitioner, the claimant, appellant claimant, had gone outside to throw the old flowers from the temple and returning to the temple. At that time, one car bearing registration number KA18, please sit down, sir, P1336 came in a rash and negligent manner and dashed against him, due to which the claimant suffered serious injury to his legs, face, eyes, hands, and immediately he was shifted to the government hospital, Ajampura, where he took first aid treatment. And later he was shifted to JP Hospital, Shimoga, where the surgery was undertaken. Again, thereafter, he was shifted to Wenlock Hospital, Mangaluru, for better treatment. Full stop. It is a case of the claimant that he was working as a priest of Sri Kukudama temple. Kukudama temple, Ajampura, as a priest, and was earning salary of rupees 16,000 per month. Due to the grievous injuries suffered by the claimant, he is unable to do his regular day-to-day activities as a priest and unable to earn his income due to the disability suffered by him. Full stop. It is further stated that claimant spent more than rupees 11,40,000 towards medical treatment, miscellaneous expenses, and other charges. Full stop. In view of the injuries suffered, expenses incurred, claim petition came to be filed by the claimant against the respondents. Upon appearance of the respondents before the tribunal, they denied the averments made, including the negligence attributed on the offending vehicle driver, and pleaded to dismiss the case on the ground of no negligence of the offending car. We'll stop. Para. On the basis of materials placed on record, both oral and documentary, tribunal framed issues. The claimant got examined himself as PW1. And the doctor came to be examined as PW2. Exhibits P1 to P18 came to be marked, whereas no evidence was adduced on behalf of the respondents, and neither any documents marked. Full stop. On the basis of materials placed on record, both oral and documentary, the tribunal awarded total compensation of rupees 3,98,022 rupees, along with interest at 6% per annum, and directed the respondent number 2 insurance company to pay the compensation. Respondent 1. Directed the insurance company to pay the compensation within a period of 1 month. Full stop. Being aggrieved by the inadequate compensation awarded by the tribunal, appellant claimant is before this court seeking enhancement. Not taken into consideration the materials placed on record with regard to the income earned by the claimant and so also the magnitude of the injuries suffered, the pain and agony, and so also no compensation is awarded towards loss of income during later period. The full stop, the medical expenses awarded is on the lower side. So also on other grounds, the compensation awarded is extremely on the lower side, same requires to be enhanced. In fact, learned counsel further contends that future prospects requires to be awarded in this case in view of the magnitude of the injuries suffered by the claimant. On these grounds, he seeks enhancement of compensation. Per contra, learned counsel Shri Krishna Kishore, appearing for the respondent insurance company, sustains the order passed by the tribunal, contending that just and reasonable compensation is awarded by the tribunal. He further contends that no proof of income is placed on record to award compensation on the ground of loss of income due to the disability. The tribunal nevertheless has taken the income at rupees 9,000 per month and awarded compensation which does not call for interference. So also on other grounds, other heads, reasonable compensation is awarded. Full stop. Learned counsel fairly submits that a marginal increase could be awarded on the ground of pain and suffering, but contends that on other heads, the judgment and award passed by the tribunal is sustainable in law and on facts. On these grounds, he seeks dismissal of the appeal. Full stop para. I have heard learned counsel for the appellant claimant and learned counsel for the respondent insurance company. there is, it is seen that the accident occurred on 8/12/2018 at 7:30 PM. There is no dispute with regard to occurrence of accident, involvement of the vehicle, injuries suffered by the claimant due to the accident, and the treatment undertaken by the claimant in the hospitals mentioned in the claim petition. The negligence is rightly attributed against the driver of the offending vehicle. Full stop. Now coming to the question of age, avocation, income, and the quantum of compensation. It is not in dispute that the claimant was aged 55 years as on date of occurrence of accident. Though it is claimed that he was doing work as a priest in a temple, no document is produced to show his income. Nevertheless, the income for the year 2018, as per the notional income chart, is 12,500. Tribunal has taken the income at 9,000, which requires to be enhanced to 12,500 per month. The appropriate multiplier would be 11, which is correctly taken by the tribunal. Same is not interfered. Error. Claimant has got examined the doctor as PW2, who's an orthopedic surgeon, and he has opined a permanent physical disability to an extent of 54% of the lower limb. Which lower? Right lower limb. Right lower limb. Due to malunion. And whole body disability is assessed at 27%. However, the tribunal has not accepted the version of the doctor and has taken the disability at 9%, awarded compensation to an extent of 1,06,920 under the head loss of future income due to disability. Full stop, error. It is to be seen that though the claimant was working as a priest in the temple, and due to lack of any material documents to substantiate the same, the notional income can be taken at 12,500. And the multiplier could be adopted at 11, considering the age of the claimant to be 55 years. The disability is to be calculated on the basis of the opinion expressed by the doctor PW2. On the assessment made by the doctor at 54% to the right lower limb, in my opinion, considering the magnitude of injuries and looking into the exhibits produced by the claimant, 20% to the whole body could be taken as a disability for awarding compensation towards loss of future earning capacity. Therefore, 12,500 into 12 into 11 into 20% would be 3,30,000 as against 1,06,920. Full stop para. Towards pain and suffering, looking into the exhibits produced and the magnitude of injuries suffered by the claimant for no fault of his, the tribunal is awarded 10,000. This court deems it appropriate to award 60,000. Full stop. Towards medical expenses, 2,63,602 is awarded by the tribunal, whereas the total medical bills produced by the claimant is amounting to 5,30,000. The tribunal has not agreed with the medical bills with regard to the ambulance receipts produced by the claimant, amounting to rupees 70,000. I do not find any good ground for the tribunal to have refused to accept those bills, considering the fact that there is the claimant is met with a terrible injury and he has attended the hospital multiple times and he was unable to either travel in a two-wheeler or a four-wheeler without being sedated, SEDATED, sedated. Therefore, considering the magnitude of injuries and multiple admissions to the hospital, this court is of the opinion that the bill so submitted to an extent of 70,000 requires to be taken on the face value and accepted. The same will have to be accepted, though copies of the original bills are furnished. The original bills are furnished merely because there is no authentic GST number or reference. It cannot be denied. Considering the fact that this is a welfare legislation scheme and an act. We'll stop. Hence, 5,30,000 requires to be awarded towards medical expenses as against 2,63,602. Towards attendant charges, food, nourishment, transportation, and miscellaneous expenditures. It is seen from the medical records that the claimant was admitted to the hospital as an inpatient for 10 months. Therefore, 300 days, the claimant was admitted as an inpatient. If 500 rupees is taken as per day charges, 1,50,000 requires to be awarded, and the same is awarded as under this head. Same is awarded under this head. Towards loss of amenities, tribunal is awarded 15,000. An additional 35,000 is awarded under this head. We'll stop. Tribunal has failed to award compensation towards loss of income during laid-up period. This court deems it appropriate to award By the way, this court deems it appropriate in view of this court, in view of the fact that claimant was inpatient for 10 months, 6 months will have to be taken for recuperation, and 16 months period will have to be awarded towards later period at the rate of 12,500 per month, which should be rupees 2 lakhs. Full stop. In view of the above discussions, the claimant would be entitled to total compensation of rupees 13 lakhs 25,000. Plus you have to add that one more paragraph. During the pendency of this appeal, the appellant has filed an application along with certain additional medical bills which are incurred post the judgment rendered by the tribunal. Considering the magnitude of the injuries suffered, this court deems it appropriate to accept the medical bills, allow the application, and also consider also award rupees 20,454 towards additional medical expenses incurred by the claimant towards the said treatment of injuries suffered in the accident. And after that, and therefore the claimant would be entitled to 13 lakhs 40,454. Accordingly, I pass the following order. What was claimed before the tribunal? What was claimed before the tribunal? What was your claim? $25 lakhs. Appeal is allowed in part. Judgment and award passed by the tribunal is modified. Claimant is entitled to total compensation of 13 lakhs also, along with interest at 6% per annum. You have deposited some amount? Satisfied. The balance compensation shall be paid within a period of 4 weeks in the date of receipt of copy of the order. All other terms and conditions stipulated by the tribunal stands intact. Yes, sir. Anything else? No, see, only that portion of the leg just above the ankle and below the knee is the portion which is now affected. Though prior to the accident, it was terribly bad looking. Post accident, he can do other job, only he cannot do that. Maybe future prospects cannot be allowed in this case. He can do other job. Future prospects, you'll have to really lay down. Bedridden agam. Oh, that is all. And you should place material. That's now, where is the material on record? That he is bedridden, he needs attendant, he needs help. Adella material bekala. Then you have to give him opportunity to defend it. No, he can sit and do some job, even in the temple. Iva ಕೊಟ್ಟಿರೋದು 13 ಲಕ್ಷ. ಆವಾಗ, which year was that? 19, 5 years. So your future prospect also has emanated from Shantaraj, not yourself. That's why, as a lawyer, you have to do your homework very well, because your client is dependent on you. We have to be thankful we are not amenable to consumer negligence. Be thankful. Yes, thank you for assisting. All right. Yes, Ravi Shankar. Ilva. All right. Request. You are seeking or he is seeking? You are seeking time. At request of counsel, there's no representation on behalf of appellant. Counsel for respondent is present, seeks time. Call on next week.
Monday.
All right. Monday. You are ready in this case? Ready in this case? Mr. Vijay Kumar?
Please, my lord.
You ready in the case only?
If other side is ready, I'm ready, my lord. Serial number 54, my lord.
54, Gopal Krishna is here, he's ready.
Please, my lord.
Yes, sir.
Please. This case,
Mic so that he can hear you.
this case, the tribunal committed an attributing 50% negligence to the appellant claimant, my lord. Only on the ground that that hospital records reveal that he was while attempting to board a moving bus, he fell down. On that basis, tribunal has come to the conclusion that attributed 50%, but actually the FIR and charge sheet does not disclose. It was a pedestrian. While walking, the bus came and hit from behind. That is the
Okay.
prosecution papers would disclose. Lordship, paragraph brief.
My lord, I'll come physically and argue the matter.
Physically?
Tomorrow or day after tomorrow, any day.
Physically, Bartharan.
Barely next week.
Day after tomorrow? Or you want next
Please.
week?
Next week.
All right. At request of both learned counsel, call this matter on 15th.
Please.
15th is okay?
Up 15. Please, my lord. Or 16th, my lord.
All right, 16th. Adhanarne Tarik.
Please.
Mr. Srikantara.
I appear for respond.
Where is Madam Suma? ECA. You are ready, sir?
I'm ready.
Madam is not here.
It may be posted on Friday
All right.
or next week.
Next week, Friday.
Yes, you are.
There may be combination of benches the Friday. We'll have it
No.
next week. Okay. There's learned counsel for respondent is present. No representation for appellant. Call on 15th. 15th.
I see.
Yes, sir. Shantaraj.
My lord, I am for the appellant in the connected matter.
Yes.
My lord, there is a delay of 18 days in filing the appeal. Delay may kindly be condoned.
Of the corporation.
Yes, my lord.
Yes.
Yes, sir. Any objection, Nimge?
No objection. Delay will be condoned, my lord. The
Non-fair.
deceased was aged about 19 years. He was a expert carpenter by profession. He is earning a sum of rupees 800 per day. And tribunal has taken income of rupees 6,000 per month. Accident is dated 9/6/2017. Parents are the claimants.
It's a case of death.
Death mein.
Yes.
We've also examined the owner of the factory and he has deposed before court. And the documents with regard to the license and trade license of were also produced, exhibit P10 and 11. The tribunal has not has disbelieved the evidence and
ಬೇಕಾಗಿತ್ತಾ ನಿಮಗೆ trial court records are required?
Yes, my lord.
required.
The three vehicles are involved in the accident.
Three ಇಲ್ಲ ಟೂನೆ ಬೈಕ್ ನಮ್ಮೊಂದು ಬೈಕ್
ಅಲ್ಲ, ಒಂದ್ ಗೂಡ್ಸ್ ವೆಹಿಕಲ್ ಕೂಡ ಇದೆ, ಒಂದ್ ಗೂಡ್ಸ್ ವೆಹಿಕಲ್ ಕೂಡ ಇದೆ.
ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ ಇದು?
ಇಲ್ಲ,
ಅದು 50% ಅವ್ರದ್ರಲ್ಲಿ ಸ್ಟೇ ಸಬ್ಜೆಕ್ಟ್ ಟು ಡೆಪಾಸಿಟ್ 50% ಅಂತ ಮಾಡಿದ್ರು. ಅದು ನಮ್ಮವರು
We'll secure the records.
ಎಸ್.
ಎಲ್ಲಿಂದ ಬರಬೇಕು ಶಾಂತರಾಜ್ ಅವರು?
ಇದು ರಾಮನಗರ.
All right. ಬರ್ಕೊಳ್ಳಿ. Shall we admit it and post it for hearing?
ಅಲ್ಲ ಇದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ರೆ ಡಿಸ್ಪೋಸ್
ರೆಕಾರ್ಡ್ಸ್ ಒಂದು ಕಾಲ್ ಫಾರ್ ಮಾಡಿ as it is.
Register, ಬರ್ಕೊಳ್ಳಿ. In connected matter 56.1, IA 1 of 23 is allowed. Delay of 18 days in filing the appeal is condoned. So you have deposited, Mr. Vijay Kumar?
Yes, yes, he has
Yes, ma'am.
deposited 50% and we have withdrawn.
The registry to delete the note with regard to deposit of amount, as the corporation has deposited the amount and claimant has partly withdrawn it. ನೀವು ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್?
ಈ ಪಾರ್ಟೀಸ್ ದೇವರ್ ಇನ್ ಬಿಹಾರ್ ಮೇಲೆ ಅವರು ಮಾಡಿದ್ರು.
All right. So you can file it by next week.
Yes, ma'am.
Registry to secure trial court records. Registry to communicate the same telephonically to the jurisdictional tribunal to secure records. Follow on. 23rd is okay? Vijay Kumar ji?
Please, Malad. Call for records, Malad. Kindly call for.
Agid. 23rd. Are you allowed?
Please,
call
please,
for
Malad.
records.
58 ಅಲ್ಲಿ
Call for records.
ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಕ್ಲೈಮೆಂಟ್ಸ್ಗೆ ಇದ್ದೀನಿ, ಅದು ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ ಮೇ ಬಿ ಕಾಲ್ಡ್ ಬ್ಯಾಡ್. ಐ ವಿಲ್.
Okay.
In the meantime, call for records.
All right. 58. At request of learned counsel, the respondent call on 23rd.
Yes.
Same
Please,
day?
Malad.
23rd. Meanwhile, registry to secure trial court records.
Yes.
In 59, my lord,
Hmm.
Mr. P.S. Jagdish has already filed wakalat for R1. My name may be deleted.
All right.
I appear.
Ready now, Mr. Lord Mariappa?
Please, my lord.
Are you ready?
Yes, ma'am. In connected matter, my lord, that is connected MAC, my lord, the same parties, that is the, in that case, they are deposited the entire amount, my lord. Here only they are contesting here. Because of the court below, the honorable tribunal has viewed that the negligence on part of the appellant here. That is not correct. But in the connected matter, that is MEC number 1173, where is that is death case mail, here injury mail.
So what happened to that case?
That case, they deposited the entire, both the respondents, that is, first respondent and fourth respondent. Have deposited the entire amount there.
So in your case, what happened here?
Here, they have not deposited the amount, some only part of the amount is deposited in the tribunal before the tribunal, my lord. That is yet to be there, we have not withdrawn that.
No, in that case, whether there is any challenge made by the,
No, my lord, not challenge.
Two insurance companies, my lord, may submit. My lord.
Hmm.
In this case, my lord, so far as against the first respondent, 50% negligence is passed on, my lord. In 50% against the petitioner himself has been passed on before by the MSCT, my lord. I am not aware about the other case. What?
ಅದು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ ಬಟ್ ಅದರಲ್ಲಿ ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ ಅದರಲ್ಲಿ ನೀವೇ ಎಂಟೈರ್ ಅಮೌಂಟ್.
See, again, the fourth respondent is Oriental Insurance Company. The two vehicles, one is lorry and one is motorcycle, my lord. I'm not aware whether in the other case, whether the Oriental Insurance Company has made liable and they have deposited, my lord.
so the liability in this present case
50% is against.
fixed against you 50% and the claimant himself 50%.
50%.
So nothing against R4,
No, in this case, no, my lord.
nothing. So they are not required.
That's
So in the other case, also same,
same means
Same
if
aspect.
he is a pillion rider, that's what I'm not aware.
Not Pillander, is a cleaner, my lord. Driver and cleaner.
you are traveling in which vehicle?
It is not traveling. Driver, cleaner, ಗಾಡಿ ನಿಲ್ಸಿತ್ತು some ಹಿಂದ್ಗಡೆ ಬಂದು, that is the first respondent vehicle is dash. And consequently, the cleaner is spot death, my lord. And the driver is the injured entire that right leg, my lord. That is the case, not that the Pillander case. I will produce that judgment and
let him
kindly after
produce,
next
I'll go
week, my lord, and connected matter
So
though.
that will have a bearing on this case.
Please, my lord.
You have not challenged that.
We have
Adil
not
also.
challenged. In this also, we have not challenged. Let him produce that judgment. We'll go through and we'll dispose it. In case-
Registry to delete the name of learned counsel D. Vijay Kumar from the cost list and retain the name of learned counsel Jagdish PS
Please,
for R1. Call this matter after a week,
Short dead.
after a week on
I saw.
16th.
Much of it.
Rishbendraya.
Vendra is not there.
ಡೌಟ್ ಮೇಲೆ ಹೋಗ್ಬಿಟ್ಟಿದಾರ ರಿಓಪನಿಂಗ್ ಡೇ ಅಲ್ಲೇ ಡೌಟ್ ಬಂದ್ಬಿಟ್ಟಿದೆಯಲ್ಲ ಅವ್ರಿಗೆ.
He was here.
You have to tell him I normally sit till 6 o'clock. Barcode. At request of learned counsel for respondent, call this matter next week. Any particular day you?
16th.
16th.
Insurance company, I think challenging the liability on the good death is not due to injury. But after 1 year of the accident,
Then stay ಆಗಿಲ್ವಾ ಇದು?
in a
Fresh matter.
ಹೌದು ಕರೆಕ್ಷನ್ ಆಫ್ ಜಡ್ಮೆಂಟ್ ಹಾಕಿದ್ದೆ ಜನರಲಿ ಇನ್ನದು ಬಿಟ್ಟೋಗ್ಬಿಟ್ಟಿತ್ತು ಟ್ರೈಬ್ಯುನಲ್ ಅಲ್ಲಿ. Therefore, I have filed the application before the MSCT and I have filed the corrected judgment. Company name was wrongly mentioned before the MSCT. Therefore, I have moved the application before the MSCT and I have produced the corrected judgment before you. ಫ್ಯೂಚರ್ ಜನರಲಿ ಬದಲು ಜನರಲ್ ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು, ಅದನ್ನ ಜನರಲಿ ಅಂತ ಮಾಡಿಸ್ಕೊಂಡು ಬಂದು
So Messrs Future General Insurance. ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ
ಈಗ ಸರಿ.
Seeking for stay. Heard. Learned counsel for the appellant. Issue notice to respondent. There shall be stay of operation and execution of the judgment and award dated 14/2/24. Passed by the second additional district and sessions judge, MACT at Kodagu, Madikeri, sitting at Virajpet in MVC number 40/2020. subject to the appellant depositing 50% of the award amount within 4 weeks from the date of receipt, 4 weeks from today. 7,44,000.
Please. Before this court, Malad,
Trial court alone.
since I am challenging liability,
Challenging liability on a deposit.
therefore I will deposit before this.
For this court.
Much. ಮಾಡೋಣ LCR ಬೇಕಂತ
ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ಲ ಬಂದಿದೆಯಾ
Registry to secure LCR, trial, TCR. Call on. Benny Ravish.
65 ಇದರಲ್ಲಿ R3 ಏನಾಗಿದೆ ನೋಡಿ. R3 is R1 is the claimant served, R2 taken the dispensation, R3 ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ನೋಡಿ. Challenge the liability please.
R3 ಯಾರು?
Owner please. ನೋಡಿ ಮೇಡಮ್.
You insurance company.
I have taken the steps also 2 times.
Your insurance company.
Please.
So you want to shift the liability to the owner.
No, ಪೇನ್ ರಿಕವರಿ ಆಗ್ಬೇಕು ಸರ್. DL ಇದೆ.
Ah.
DL ಇಲ್ಲ ಹೇಳಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ವಿ. ಆಮೇಲೆ ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ರನ್ನಿಂಗ್ ಕಡಿಮೆ ಆಗ್ಬೇಕು ಸರ್. ಆಮೇಲೆ ಲಾಸ್ ಆಫ್ ಡ್ಯೂರಿಂಗ್ ದಿ ಲೇಟ್ ಡೇ ಪೀರಿಯಡ್.
Item deliver ಆಗಿದೆ. Item is delivered to R3.
Please, any date next week. I am ready for disposal. ಅದು ತೋರ್ಸ್ ಅಂತ ಹೇಳಿ kindly direct office to show the what happened in the earth.
As per the order sheet notings, it is seen that as per the order sheet notings, it is seen that the notice to R3 as within inverted comma, item delivered. In order to facilitate appearance of R3, call this matter on
21 please.
21,
Please,
21st January.
I am ready.
For enhancement of compensation, so the claimant's appeal.
Sixty-seven, my lord, both parties may be directed to file assets and liabilities, my lord.
Registry to secure trial court records. Call on.
For Lokada, refer to Lokada.
ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ. He has to agree.
Yes, my lords.
The insurance companies. Whether they have filed any appeal,
No, my lords. Only announcement.
next date ಮಾಡುವ.
Fifty-seven, my lord, both parties may be directed to file assets and liabilities affidavit, my lord.
A for permission to file additional documents. Statement of objections, respondent. Where is Pattabi Raman? Both the petitioner and the respondent are directed to file assets and liabilities by way of an affidavit. List this matter on.
We have not received the assets and liabilities till from the clients, my lords. I pray for time to apply the assets and liabilities, my lords.
You're for?
I'm for the appellant, my lords.
All right. So there is a case and counter case, is it?
Yes, my lords. Both the parties had to,
So you
Like
are
the
appearing
assistant-
for the wife or husband?
I'm appealing for the husband, my lords.
Same order will pass here also. Nobody has filed assets and liabilities.
No, both the parties haven't filed, my lords. We are trying to get it from the client. We're not able
Learned
to.
counsel for the petitioner, husband
Yes, my lords.
seeks time to file assets and liabilities. So also to the respondent to file assets and liabilities by way of an affidavit. Call on.
Much obliged, my lords.
Respondent, kindly time may begin.
Active counsel.
Counsel for petitioner is absent. Respondent counsel seeks time. Call on. Huh? Next week, but other than like 24th matter.
Much of them.
Petition in this case, my lord. This is the case where, my lord, the respondent wife has procured an order by suppressing that she is a working woman. The said notice was brought to the notice of the honorable trial court as well. But, my lord, there even in the cross-examination, she suppresses that she is a working woman. Thereafter, my lord, we file an RTA before the state government in the place where she was working. Then we receive a document saying that she is a working woman. Once we produce that and challenge the appeal over here before this honorable court, she comes before this honorable court after an year. And then the respondent will undertake to file the affidavit, and then she has accepted that she is a working woman right now. So on the previous occasion, it was posted for the filing of the affidavit. They filed the affidavit and they have confessed that she is a working woman. Now the matter is up for consideration on the orders passed by the trial court on the maintenance application.
How much is awarded?
The amount is 10,000.
What are you working as?
I'm working as BBMP lineman.
What is she?
BBA
working?
Bescom. She is a graduate. She has done her D.Ed, which she has suppressed even in her.
How much she is earning?
She has been earning around 8 to 10,000.
And what
She
you
has
are
earned
earning?
around 72,000.
What you are earning?
I am earning around 40,000. 40 to 40.
Children?
There are no issues born out of the wedding.
Divorce petition is filed?
Divorce petition is filed by the husband.
Pending.
It is pending.
All right, we'll have it next week. He is not here.
Please.
That counsel for the petitioner is present. There is no representation for respondent. Who is appearing for respondent, Ramappa or Narendra Babu?
Ramappa is not appearing. The other person. Narendra is
Narendra Babu.
PNS. Narendra Babu. He was here in the morning. No, I don't know. He was here in the morning. He went to
Must have
tell.
thought it will not reach. All right.
He in fact told he'll be returning. I don't know.
We'll have it. So affidavit is filed by them.
But affidavit is filed confessing that she is a working woman.
So it will have to be decided on merits, that's all.
It has to be decided on the merits.
Let's call this matter on.
Apart from that, my lord, the main concern is over here, my lord. Woman seeking the advantage of the court's orders, my lord. She has gone ahead and filed an execution petition. Even in the affidavit which she has filed, my lord, she has suppressed that she was working elsewhere also. She has only confessed one place of working wherein we have filed as an RTI. Apart from that, the other places where she was working, she is suppressing before the honorable court. By misleading, she is taking that. So the culture of misleading the honorable courts and making the men as victim has to change. That is the only concern for this honor.
Take it to court.
Please, please.
It's a death mail. There are 2 points involved, my lord. One, the
24.
74.
New Sridhar alla?
Allala, Shyam Prasad on behalf of Sridhar.
On behalf of Sridhar. Death case, final hearing. Barbekala, Ravi Shankar. Who's going to argue, Ravi Shankar or Venkata Reddy?
Ravi Shankar, I think. Other day he was present.
Right, then we'll have it next week. Learned counsel for petition appellant is present. No representation for respondent. Call this matter on. 16th?
Serial number 78, my lord.
76. Request of both counsel, call this matter on. Siddhappa BM. SV Hegde. At request of learned counsel, call this matter on. Yes.
Number 70 was a stay, my lord. The stay may be extended, please.
Sorry?
There was a stay, my lord. In
Yaudra-
serial number 70,
70. no?
70,
Interim
there
order
was an
extended.
undertaking from them that they'll not be precipitating on the execution petition.
Interim order extended till next week. Yes, 78.
I am ready. If other side is ready, my lord, it can, a small enhancement.
Illa, aurilla.
Please, my
Ramesh
lord.
Kumar, RV and law. No representation for appellant. Counsel for respondent 2 is present. Call on.
Date, my lord.
17. Lakshmi Shrawat, request of learned counsel for both parties. Call on. No representation either side. Call on.
For enhancement, my lordship.
Ibu Raju.
ಇವ್ರು ಬೇರೆ ಮಾಡ್ತಿದ್ದಾರೆ the connected matter, my lord.
Idea. One more matter is there?
2 more matters, sir. I'll give this slip.
Give the number. Call these matters along with. Call this matter along with. List on. Give the number.
On behalf of Jagdish, appellant.
Counsel for appellant seeks time. Call on. Request of both counsels. Call on. Yes, madam.
Here for respondent, my lords, insurance company.
Damages.
Damages and enhancement, my lords.
Sure. At request of the claimant, call this matter on. Counsel for respondent is present.
Obliged. ma'am.
None appears. Call on.
There is some inconvenience or idru is left, my lord. Any date may be fixed.
Yarge. You are for whom?
On behalf of appellant, my lord. Yes, just inform me to just.
Request of appellant. Call on.
Yes.
Death case. Counsel for appellant is present. No appearance for respondent. Call on. Rangi Gowda. Let's call this matter on. And PS call on.
Appear for respondent, my lord. When this matter, my lord, total 4 appeals, out of which, my lord, I make an application for release of amount, my lord, in 2 appeals. My application, my lord, still pending, my lord. They are challenging, my lord, as on the date of the accident, the driver of the offending vehicle having learning license. That is the defense taken by the company.
All 4 are insurance appeal.
Please.
Right, we'll have it next week.
And next week,
Counsel for, none appears for appellant, counsel for respondent is present. Call on.
my lord, my application is still pending. My
How to pass order without hearing him?
Please. Hearing and IML ಸ್ವಲ್ಪ
Oh.
ಹಾಕಿದ್ದಾರೆ.
Why did it come?
The date matter, my lord, date matter.
No, why it is posted for
Final hearing, my lord.
admit agi ಎಲ್ಲ stay ಎಲ್ಲ ಆಗಿದೆ.
ಎಲ್ಲ ಆಗಿದೆ ಸರ್, ಅಡ್ಮಿಟ್ ಆಗಿ ಸ್ಟೇನ್ ಆಗಿದೆ.
Then once you filed IA, it should come for hearing on IA.
Please, my lord.
All right, let's this matter,
Even, my lord, they have succeeded.
the stage
They-
of hearing IA.
Thank you much, my lord.
None appears, call on. Same.
Appearing for respondent number 1, my lord. Motor vehicle,
One submission, my lord. Behalf of Shankar Reddy, sir, I am representing my lordship. He has deposited before tribunal, my lord, 1,40,000 rupees they have deposited. They have produced acknowledgement before
Learned
filing
counsel
court.
for the appellant submits he has deposited the amount as ordered by this court.
Lord, we have not received any of the documents. We only received a few pages of the appeal memo. That's all.
Copy of the appeal memo to be furnished
We
to
have-
learned counsel
along with
for
the documents,
respondent number 1. Along with documents.
Great.
Call on. N. Kumar. Adinath Narde. N. Kumar. None appears. Call on. Mr. Anup. You are waiting for which matter?
57 and 87, my lords.
'87 is adjourned to 20. ಗೊತ್ತಾಯ್ತಾ ಡೇಟು?
ಗೊತ್ತಾಯ್ತು.